It is wrongly listed in motion. It may come up for admission after 2 weeks. Admission.
You are Mr.
SD Purkas.
SD Purkas. Submitted. After 2 weeks.
2 weeks. Interim order may be continued.
Interim was there.
Yes.
Interim be continued.
Obliged.
May I please, Sir Lordship, I beg to mention item number 28. Okay, we have filed our objection. Our objection may be called for.
28. You have already filed your objection.
Highly obliged.
May I please, Lord? Lordship, I beg to mention item number 32, Lordship.
32.
No, 32. Okay, CD not yet received, Lord.
CDS what?
CD not yet received, my lord. My lord, he himself, my lord, stated to me that, my lord, in this case, my lord, first it submitted.
No, Lordship, I have not said. I am perhaps submitted. Since case is pending from last 3 months. So I asked him to inquire the matter.
If that file, my lord,
You will get the instruction.
yes, well, otherwise, unnecessarily, my lord, if my lord, first it file away.
My lord, I beg to
Get
mention,
the instruction at 2 p.m. If it is not there, then we'll get you.
Lordship.
and I beg to mention item number 20, my lord. Kindly taken a back to my lord.
The admission matter. We
Admission.
just
Matter-
looking it. Let us see.
Matter pertains to Zimma, my lord. So, item
We'll try.
20. Kindly to my lord.
We'll try.
Obliged.
May it please, Your Lordship. I beg to mention item number 22.
Yes.
May adjournment for the day.
22.
20. I'm appearing on behalf of S. Munir.
Yes.
22, my lord, can please, my lord, receive.
Yes. It's a POXO matter or what? POXO, I think. You want
Next.
an adjournment? You
Yes.
go today. Why S. Munir is
Out of station.
out of station? Out of station. Scan copy for the audit. Yes, what happened?
On, my lord, 29th of August, 29/8.
Next week, ma'am.
Next week, not possible.
Next week on, then, my lord, on 21/8.
Much obliged.
May I please, Lordship? I wish to mention item number 9, my Lord. The Learned English Council is out of station MZ Shah. And, my Lord, this matter perhaps wrongly listed in motion column. It should be listed for bail here. My Lord. There is an interim order.
Is it interim order?
Lordship.
Oh, yes, the interim order.
My
Lordship.
lord, in that order, my lord, CD was not called. CD may be called for.
City may be called. No. City has no.
You are Mr.
H. Ahmed on behalf of MZ Shah.
Or Mr. H.M. on behalf of Campus Council, Mr. M. Shah, Mr. Report Constituency. It is submitted by Mr. Ahmed that the case is wrong. That the motion column is not listed. You record. In the meantime, in the same time, it is submitted by Mr. Bot that CD not received. Stop. And should reminder. It may be extended till next to this yes,
Yes. On 29/8/24.
Interim may be
your
continued.
interim will be extended.
Obliged.
May of Lordship, this is my item number 33, Lordship. And the password for the Lordship, CD was called for, CD may not be there, Lordship. I have an interim, Lordship.
33. Is what according
Yes, CD not received, my lord.
I have an interim, Lordship.
interim be continued till the next date of 16. Reminder, yes.
On 28/8, my lord.
20.
Interim shall continue.
2/8 or
Yes, my lord. 22/8, my lord. 28th of August.
28th of August.
Yes, interim will continue, Lordship.
Yes, interim will be.
Obliged.
May I be allowed? What if I beg to mention item 18, 1-8? What if I may be allowed to withdraw this petition as not
You want to withdraw the same?
lot? 18, item number 18. I am for the petition.
Yet the respondent number 2 was already appeared, I think.
If you are notified, I will inform you.
18 to divorce. 1 8.
This is for passing of the FIR law.
On the last occasion, most probably you took steps, and the name of one Mr. D.S. Deka is already appeared. So you want to withdraw this?
I want to withdraw. I was not touched.
You are Mr. A.M.S.
Majumdar.
As per instructions. Just intimate the other side.
Lordship, I will inform.
Intimate with counsel. They comes to intimate the counsel of the
Oblige.
May I please, Your Lordship? I beg to mention a regular bail, Lordship, for listing, Lordship, tomorrow, Lordship.
Tomorrow can it be or Friday? Tomorrow is Friday. Oh, so
Thursday.
tomorrow is Thursday. It can be tomorrow. 26. 26.
Friday.
26 will be Friday, yes.
Much
Wait, please, Your Lordship. Lordship, I beg to mention item number 36, Lordship. In this case, I am on interim bail, Lordship. The case is perhaps not there, Lordship. CD not received.
CD
Interim may continue. Lordship, let this matter come up with the AB number 1458/2024, Lordship.
1458
58.
of 2024.
No, 24.
This accordingly to as well. This is also AB. Na?
Yes, yes, Lordship.
AB
Out of the same case
2024. Interim, yes, what happened?
In time is there.
Yes, interim is.
On my lord, 21/8.
That case, Lordship, today that was listed before the court number 18, Lordship. It was fixed after 2 weeks, Lordship. No date has been given, Lordship.
Application number
1458. Let the matter be come up after
as the
6
as
Lordship.
case is fixed for case date, that's why we are giving a date.
My lord,
Otherwise, it will have
it will be required because I will have to call for the case.
Yes,
time.
Yes, yes.
calling
Then,
for the
then
case diary. So it may come up with
21, Lordship.
21.
Highly obliged.
Item 15, no, there is small error in there.
Item.
Item 15,
Ah.
there is small error in the petition case 2. You may allow to correct in hand. Small error.
Small error also you have to correct it by.
But the spare portion is correct. Only court.
So that I don't know. As
Yes, yes,
notification you have to correct not by hand correction.
Yes.
It cannot be corrected to your hand. It
Yes,
has to
that-
be furnished. Huh?
That I am aspiring. I'll do that. If court permit me now.
Hand correction. No, no.
Maybe, Lordship.
So you are going to file an addition. I mean,
No. Otherwise, everything is correct. Spare portion correct. But in
what do you want now?
I mean, allowed to correct.
No, this is not permissible now. So you have to file and apply.
Maybe, Lordship. Lordship, with concern of other side, back to mention item number 42.
40,
42. 42.
22,
42. 42.
42.
Matter may be adjourned for the day, Lordship.
Yes, why?
Petitioner advocate Mr. D. Hussain is unwell.
Is unwell. With the consent of the advocate, his counsel, Mr. D. Hussain is unwell. List after 2 weeks. It will be listed after 2 weeks. But do you know, is there any interim?
No.
No interim.
No.
Okay.
The charge sheeted case, my lords may call for the record. It's pending before my lord. Special Judge Kam Pokso, Kamrup Metro.
Special judge?
Special Judge Posco, Kamrup Metro. special case number 173/24.
Special case number 173
Yes, ma'am. Of
of
20
24.
24.
24.
24. Registry.
Scan copy of the registry will be. Yes,
19.8.
19.8.
19.
Can it be on 16, my lord? Sorry, my lord. On 14, my lord.
1/4.
1/4. I'm obliged.
1/4.
May I please, Lordship? 483 application, Your Lordship.
Yes.
Your Lordship, FIR is on page 10, Your Lordship. I was found arrested in connection with Hathigao PS case number 87/2024, Your Lordship. Subsequently shown arrested in this case also. 457 380 is there.
Kothakot, can you remember same?
Yes, my lord.
Yes,
The
Lord.
persons were Your Lordship has granted bail. But here in this case, my lord, petitioner is shown arrested on 11/5.
11?
11/5, Your Lordship. I have stated in paragraph number 8, Your Lordship.
Oh, 11/5.
11/5, Your Lordship.
Considerable period he is in custody.
Yes.
457 is there, but otherwise he is more than 2 months. I think.
Yes.
Is there any recovery from your position?
Nothing, Your Lord.
You have NXT.
Because, my lord, this is in this case, my lord, Hathigao PS case, if I can remember, my lord, here some recovery is there. But whether, my lord, from this other two cases, my lord, Hathigao PS case 86 and one Bosisto case, all these accused persons were earlier arrested, my lord. And same modus operandi, my lord, by breaking the, my lord, door at night, my lord, they committed this theft, my lord. All these accused persons.
Is there any note regarding him also that he has earlier?
Yes, my lord, from the forwarding report is at
Forwarding report you have annexed?
page 21.
20.
Now present case Vasishta and other two was Hathigao 86 and
The present case is Hathigao 87.
Vasishta. Present case is Vasishta.
This is Vasishta.
Then, my lord, I have wrong file.
No, it's okay. It's wrong. It's right information only. It is present case Vasishta.
Yes.
And those two co-accused, they were earlier arrested in 86 and 87 Hathigao.
Hathigao.
That's
Hathigao 86.
Now here you have annexed your forwarding report in which page?
Your Honor, it is dated 6/6/2024.
No, in which page you have annexed?
Page 17, Your Lordship.
17.
17.
Brown numbered the accused persons earlier also involved in many cases. It seems heavy story.
So he also was arrested in Hathigao 87.
Your Lordship.
Yes.
In those cases, have you fixed any date? I don't know.
Regarding the present petition.
Regarding the, no, not regarding the present petitioner, for the other two petitioners, whether any date has been fixed or?
No, all those cases dispose of, my lord. Regarding those petitioners, my lord, case dispose of. Your lord,
those were
dispose of.
Here, recovery from him, recovery is not there.
Yes.
He is also shown arrested.
shown arrested.
You want to
In other cases, Mr. A.K. Singh, Your Lordship.
So Mr. A.K. Singh. A.K. Singh. Had Mr. A.K. Singh done a consequently. And also had Mr. report that there should be it is submitted by Mr. Singh that they were definitely 07. And it was shown arrested. Okay, so after that will because of public policy. 8 years behind the bar since last
In this case, from 10/6/2024, Your Lordship.
In this case from 10/6.
10/6.
Then why take 5?
Madam, sorry, in that case, I have a wrong file regarding the present petition. Shown arrested on 10/6.
Not 2 months.
No, yes.
All the accused persons are arrested on the same day, Your Lordship, on 10th of June, Your Lordship. And similar order has been passed in those cases, Your Lordship.
So those were after perusal.
After perusing the case,
Your
there.
Lordship.
After perusal.
Your Lordship.
Then let the case
Yes, well, any short date may be fixed, well, I'll get the case there. On 20, Tuesday, well, I can get the case, 30.
30.
Yes, ma'am.
Oblige, Your Lordship.
This is 24.
May I please do this? This is 483 application. Allegation is under section 21B/29, Lordship. And today's I was arrested on 15/6/2024, Lordship. And today's 38 days. 84.65 grams of recovered from both the prisoners. Yes, sir. It is intermediate quantity.
Call it for the case diary.
Yes, ma'am, NDPS case, ma'am.
He was arrested on 15/6.
38 days.
On 31/8, ma'am.
31.
Lordship, it was mandatory period will be
31/7. 31/7.
Yes, 31/7 will reach.
Otherwise, ma'am, 9/8. 9/8 would
8/8,
be.
9/8, 9/8.
In this case, Lordship, the petitioners were arrested on 21/6/2024, Lordship, and allegations under section 21B/29, and recovered quantum is Lordship heroin, and it was recovered 94.22 grams, Lordship.
Here they were arrested on 21/6.
21, and today is 33 days, Lordship.
On 14/8, ma'am. 14/8.
Must have been.
Lordship, may I pray this matter may be taken up for after some time, after a while, madam. I'll
Mr. Aisana, in this case, instruction in the police.
Report regarding my case registered or not against all the accused persons.
It's restored.
But there was a direction also to appear before.
Yes, yes. We have already appeared here, Lordship.
We have already appeared.
We have already appeared.
Here, note is not there.
No case.
Regarding it, no case is there. But regarding
their
appearance,
appearance, yes,
it's
ma'am.
not there. Have you appeared?
Yes.
Anyway, it's not a problem. Heard Mr. Priyanka, the London Council for the also heard Mr. Biwat, the direct additional people. Mr. Bottomore furnished the written report from the officer in charge of Fakirganj police station, district 50, wherefrom it is seen that no case has been registered against the present accused for present petitioners, and even after thorough search, even after so he reported that after thorough physical search, thorough physical search, comma, no case has been found. No case is found against the present petitioner. Present accused not against found the present petitioner. Are not the accused. There is no report in regards to appearance of before the officer in charge of the investigation. So, for order dated 24/2024, they were instructed to appear before the office of the concerned police station. However, considering the report, the argument is seen that no case is registered against the present and accordingly, it present with applications become part of their in connection with the observation we asked.
All right.
Well, item number 8 is wrongly listed for motion earlier, my lord, by order dated 25/6B and FSL call for, my lord, 22C of the NDPS Act, arrested on 10/6/24.
Not arrested, FIR. AB.
Oh, sorry, my lord, AB.
Earlier, Your Lordship, as per order dated 25/6/24, Your Lordship, actually what has happened, Your Lordship, calling of the CD and FSL report, Your Lordship, that is not reflected in the order dated 25/6/24.
Yes, somehow it is missing.
Yes, Your
It
Lordship.
was typed by one stenographer. She is under training, in fact.
Okay, Your
so he has most probably missed out also.
Earlier also in other case, Your Lordship, the same thing has happened.
Oh.
On that particular day, or I think day before that, on 24th or 26th, Your
It
Lordship.
is a mistake, I think.
Yes.
It is a mistake on our part.
No, Your
So we are calling for the case diary.
Okay, Your Lordship. That may be reflected in the order, Your Lordship.
Yes, obviously.
Yes, Your Lordship.
Part the London Council also Mr. Igor. It is seen that as per order dated 25/06/2024, the inflammatory is wrong by 24. CD and the FSL report was not called for. Inadvertently, the CD and FSL report was not called for. And though it was it was not called for. Inadvertently, the inadvertent also. Accordingly, the CD and the along with the FSL report be called for. List, yes, for
On my lord,
5th of August, Your Lordship, if
5th
possible.
of August, not possible. NDPS case, my lord, on 21/8.
21 year, Your Lordship, AB, Your Lordship.
Yes.
Since 10/6, since 10/6, Your Lordship, on 10/6 FIR was lodged. Your Lord, since then, she is apprehending, Your Lordship.
22C of the NDPS Act, my lord, on 28.
Commercial matter, yes,
8, 208, my lord, 20th of August.
Your Lordship, some sort did, Your Lordship.
On 14/8, my lord.
14/8. Oblige, Your Lordship.
May I pray to Lordship? Lordship, in this case, Lordship, also POCSO Lordship, and call for the CD and Issued notice to the
submitted
respondent
to
number
be
2.
the informant.
Yes.
Informant of notice gift
Humanly
to
no.
Police station, report the office of the public prosecutor and registry and the public prosecutor. Also called for the. It is not chartered.
No, Lord.
Not called for this according. As the notice will go, so we are listing it on in the month of August.
Yes.
You take steps for the
Yes.
format. Yes.
19.8, madam.
19.
19.8.
All right.
At this stage, Your Lordship, I am only praying for issuing notice, Your Lordship.
Issuing notice.
Respondent number 2.
Oh, yes. We can also call for the case
Sorry, ma'am.
that speeches. Notice prohibitable. Speeches prohibitable. Here also 19.8 can be given or
Yes.
21.
21.8.
21.
All right. May I please, Your Lordship?
Yes.
In the anticipatory bail application, Lordship, there are two FIRs, cross FIRs are there. The FIR against whom I am here, Lordship, at page number 15. At page number 15, Lordship.
So it is registered new under new.
Yes, Lordship. Under new
311.
under new act. Later on, Lordship, my mother also filed another FIR, which is at the second FIR, which is at page number 31, Lordship. Page number 31. This is the true story. The informant's daughter was my wife. As she called me when I reached at her home, they attacked me. Lordship, may kindly peruse these photographs. This is my condition, Lordship. And now they have filed this FIR. This is my condition now, Lordship. I have also annexed this photograph with this petition, Lordship. So, Lordship, my prayer is that both the case diaries may kindly be called for, and in the interim, Lordship, I may be protected because of my condition, Lordship.
So you are still in hearing? $311 is with Dr. H, na?
Yes, ma'am.
Only one section is added against me, that is 311. But in my mother's FIR, which is at page number 31, there are several sections added, Lordship. Crime committed by them, and later on they have filed this, the first FIR against me, Lordship. This is the fact, Lordship. I have shown, Lordship, the photographs. What is the condition they have done to me, Lordship. And Lordship may kindly also peruse page number 16, the police note. I am referred to medical by police, and this is the note, page number 16. Only because of my serious condition of health, the police didn't arrest me, Lordship. So I may be protected, Lordship. This is not POCSO, Lordship. This is not 376, Lordship. So I may be protected, at least in this case, Lordship.
case,
Lordship.
on the basis of your FIR of your mother, the case was, one other case was lost.
Yes, Lordship.
This was lost on 3032 only. Why?
That is at page number 31 and
The case is registered under 109.
109, 118 within bracket 2, 303, 3 within 5 of BNS.
109 is also there, no?
Yes, Lordship. This is the FIR registered under this section, which is filed by my mother. And I am here for against the FIR, which is a page number 15, that is registered only under section 311 BNS, Lordship. So, Lordship, both these case days may be called for, and till then I may be protected, Lordship. This is my prayer, Lordship.
My lord, he submitted that considering his seriousness, my lord, his injury, my lord, police has not yet arrested him. So, my lord, then, my lord, police knows everything, then where is the apprehension, my lord?
Apprehension is there, Lordship. Police regularly visiting at the hospital, and this is the note. The note is also there. Police note is also there. And so, Lordship, my statement, I will give my statement. At least I may be protected, Lordship, at this stage, Lordship. Both these case days may be called for, Lordship. If anything found against me, then my interim may be rejected.
Subject by Mr. that the mother of the present earlier lodged an FIR against the informant side and informant side where it is alleged that they had tried to commit murder of the present patient. At the same time, Mr. Somo also produced some photographs with head injury of the present patient. It is further submitted that after filing the FIR by his mother, the present FIR has been lodged with some false information. Mr. Somo further submitted that it is the place of occurrence and considering the considering the serious condition of the petitioner, he was not seriously connected with this case and was brought to for medical treatment. However, the defendant police is visiting and in the hospital also, and hence he has apprehension of being arrested in connection with this case. For prayed for some interim protection considering his health condition. Mr. Nexpera, Mr. Paul put something in this regard that the personnel police did not arrest the present accused petitioner considering that there is no probability of any, there cannot be any apprehension of arrest. Interim protection due to call for the case date of Jogi Kopa PS case number 112 of 2024
and 113
under section 311 of BNS, and also call for the case date of Jogi Kopa PS case number 113 2024 registered under section 109, 118, 118 subsection 2, /P03 subsection 3, 3
within bracket 5.
within bracket 5 BNS. I go to BNS. Okay, you'll be under interim protection.
Lordship,
Interim protection you will be.
On 27/8.
You will be under interim protection. What do you want?
interim.
Yes.
Yes, I need interim. Lordship.
You are already granted PT.
Oblige. Deeply obliged, madam.
When?
27/8/24.
May I please, Your Lordship?
Yes.
What are the application, my lord? Lordship, on this page 13 FIR, my lord.
Okay. Yes.
My lord, may I read it? With due respect, I beg to state that the accused person is not known to me. The bypass road construction is going on nearby my house. On last 3/4/2024, I met with an accused person and he said that he has some works. On the next day, the accused person came to my house and told me that he is having a job to provide me, and for that a new motorcycle is required to be purchased. And I said that I have no money, but the accused person told me that he will pay the down payment. Accordingly, I agreed, and on good faith, 4 April 2024, at about 1 p.m., the accused person took me to Yamaha's room at Sunai Road, where the accused person had made down payment by using my Aadhaar card and PAN card. A motorcycle bearing chassis number so-and-so, engine number so-and-so, model Yamaha so-and-so was purchased by the accused in my name on finance. Later on, we came out from the showroom, and after some time, the accused requested me to let him for a test drive of the motorcycle by keeping me standing nearby the road, and the accused moved away with the motorcycle, had not returned back. I tried to contact with him over mobile phone, but was found switched off. It is therefore prayed kindly take necessary action. This is the FIR, my lord. But I am not main accused, my lord. I am not in the name FIR, my lord, and he is arrested, my lord. He is now behind the bar. So police are searching me here.
Why police is searching you?
No, see,
Why police is searching you?
no, see, he is my neighbor, my lord. He is my colleague.
Your Lordship may kindly come to page 18 of the other accused persons, my lord. Page 18 from the ground of arrest last question, my lord. How this type of, my lord, techniques were used by these accused persons, my lord. These are new techniques, my lord, of, my lord, committing theft of these motorcycles, my lord, vehicles, my lord. Your Lordship may kindly come to ground of arrest of the other accused persons, my lord, because in the FIR itself, my lord, stated that unknown person. Then these are the ground of arrest, my lord, that the arrested accused person is the perpetrators whom were found directly involved with the new art of stealing motorcycle by way of cheating and deceiving people with a very professional and planful manner. And there are 4 numbers of motorcycles, 1 Yamaha, 1 Hero motorcycles having without any number plate were recovered from their custody and seized during investigation done so far. Then, my lord, ground number 4, my lord, 3 and 4, that the arrested and forwarded accused could not produce any documents of the said 4 numbers of motorcycle which clearly established that these were kept by them or holding by dishonest means. And 4, my lord, regarding which are the relates to the contents of the present FIR, my lord. Ground number 4, that the arrested and forwarded accused had confessed that they are being in practice in a new idea of stealing motorcycles with a plan that they used to communicate with a one-time SIM card with people, offers them to provide them job for which it needs a motorcycle. The contents of the present FIR also reflect the same, my lord. As people shows inability to make down payment for purchasing a new motorcycle, then the accused takes scope to make the down payment in favor of the victim to build up a good faith. After purchasing a new motorcycle on finance in the name of victim, they used to take a test ride. On request from the victim. Once the victim lets the accused for a test ride, then the accused used to flee away with the motorcycle. This is a very new professional idea of stealing the motorcycle. So initially, my lord, the accused person introduced with the my lord, victim, my lord, assured them to provide a job, and for that job, my lord, he needs a motorcycle. And thereafter, my lord, taking his all these documents, my lord, they took a motorcycle from the my lord dealer, and thereafter, my lord, in their name now motorcycle is my lord is there, my lord. And thereafter, my lord, on the pretext of taking a test ride, they may not flee away from the spot. This is the new technique. So vehicle is in the name of the victim, my lord. So, my lord, this is in a plain manner how this new tactics.
Suppose taken on the PMI also has
yes.
been given by the
has
victim
to
only.
be the victim, my lord.
Because his other SIM, etc. are used for
Yes,
it.
And the stolen
the
bike is
contents of
recovered.
the FIR is also same, my lord, from the vehicle.
And all the accused persons arrested, my lord, and recovered the bike motorcycle. And nothing recovered from the petitioners, my lord.
Okay, CD report.
CD, my lord, on,
Yes, bro.
on 14/8, my lord.
14.
14.
Till then, my lord, some petition will be.
That's fine. Oh, but how can it?
Obliging.
May I please, as your lordship? My lord, this is a pre-arrest bail application, my lord. My lord, may be pleased to find the FIR is at page 18, my lord.
Yes.
May I read, my lord? The subject on 9/7/2024 to the officer in charge, Kalain Police Station, Kachar, Assam, subject FIR with due respect. I beg to state that today at around 5:30 p.m., one Sri Ranju Sinha, resident of Ramnagar, near Don Bosco School, Silchar, Kasar, Assam, mobile number so-and-so, and Subhendu Sinha of so-and-so, Kasar, phone number so-and-so, came to my office situated at Padritila, Burunga, Part 1, near San Vani School, and threatened me with dire consequences as they told me that if we fail to give commission to them in procuring the lands of Burunga Part 2 near Hilara railway station, then they will kill me. Further, they have abused me with an abusive communal language as they have hinted me as Bihari, and they told me that how a Bihari person can work in Assam. They have also told me that a person from Bihari community is fooling people of Assam. These two persons have asked me to hand over adequate money, otherwise they will jeopardize our factory setup activities. They have also abused the company with filthy languages, which is not at all acceptable. That's sir. I am deeply frightened by the above abuse, as I am doing the job of the company very diligently, and if they obstruct us in our work by using the force, then we will not be able to open our factory because of these miscreants. This kind of criminal activities has ruined our project, and we apprehend that these two persons will create problems in future, as they have abused me physically and told they will not allow Star Cement to open the factory here. Therefore, I request you kindly to register a case, make an inquiry, arrest these culprits, and do the needful in accordance with law. My lord, the case of the petitioner, my lord, is that I am a, my lord, licensed property dealer, my lord, working in Pune. My lord, the informant company is also, my lord, working in Bombay, and they have various branches, and my lord, they also wanted to set up a company, my lord, in the district of Kachar, as in the, my lord, area defined in the FIR also, my lord. And therefore, my lord, I have been entrusted as a property dealer, my lord. I have annexed my license, my lord. My lord may be pleased to verify is at page 22 is the translated part, my lord, and the 23 is in the Marathi language, my lord. Issued by the, my lord, Mumbai Dukan Sanstha Adhiniyam on 27/3/2012, my lord. Until date, my lord, on the strength of this license, my lord, I am dealing with, my lord, property dealership on commission basis. My lord, it is admitted fact that, my lord, this property dealer, my lord, works on commission basis, my lord. So, my lord, they have, the informant company came to an agreement with me that I should, my lord, find out a suitable land in the district of Kachar, my lord, in this suitable area. Accordingly, my lord, by using my manpower, my lord, I have found a suitable land and shown the land to the, my lord, these informant, and they were very happy with the, my lord, area. and now, my lord, they wanted to sideline me, my lord. They don't want to give me the my lord, the desired commission amount which I am entitled. Only to deprive me, my lord, from that commission. This is a fabricated and concocted affair has been designed, my lord, that I should be restrained from getting the commission amount, my lord. My lord, if we go by the, my lord, language of the affair, my lord, till date no offence has yet been committed, my lord. I have not extracted any money from them. Even the entire affair, if we go by the first part and the second part, my lord, both the parties also contradictory, my lord. I have not assaulted physically, but in the second part, he has said, my lord, that I have assaulted physically, my lord. This itself reflects, my lord, there is something fishy, my lord. So, my lord, investigation is going on. Police is searching me, my lord. My lord, actually, I am a resident of, my lord, Mumbai, and which I have also annexed my Aadhaar card, my lord. I have a link, original link within the Kachar district, my lord. That's why I have taken help of some of my friends, my lord. And those friends are also, my lord, my lord, with the hope that the commission amount will be provided, my lord. So, my lord, at this moment, my lord may be pleased to call for the case, my lord, diary. And, my lord, as there is no offence has been as such, my lord, till date has yet been committed, I may be protected, my lord, with an interim, my lord.
Otherwise, my lord, this kind of activities are, my lord, against the state, my lord, threatening all these, my lord, companies, my lord. So, my lord, regarding interim, my lord, here I will leave it to your lordship. Only CD will reveal the full fact. Otherwise, my lord, these activities are, my lord, not
He is in Mumbai, or you have given his address at Ramnagar State.
My lord, yes, my lord, I have originally I am a, my lord, man from that place, my lord, of this Kachar district. But from last 20 years, my lord, I am residing at Mumbai, my lord, doing my business there in, my lord. That's why I have been, the Aadhaar card reflects the Mumbai address, my lord. I have annexed my Aadhaar card also, my lord, is at page 25. And, my lord, this communal statement which he has alleged, my lord, I also belongs to the community that I can utter this type of words, my lord. These are all concocted allegations, my lord.
Otherwise, my lord, these activities are against the interest of the state.
No, my lord, I am helping the state, my lord. I have found out the plot, and they can very easily set up. The construction is also
Only
going
CD
on.
will reveal, my lord.
My lord, I am helping the state, my lord, otherwise.
The fact that the petitioner is a property dealer, and he had a, but the informant is not a property dealer. He wants to.
No, my lord. He is a person belongs from Star Cement Company, my lord. He wanted to set up a factory at, my lord, Kachar, my lord.
And he is a mobile and it must have done, and the informant is also a resident of Mumbai, and who wants to set up a factory in the area of Aadhaar. And accordingly, he presented and same for him for a commission. But the complainant, instead of providing him a commission as a commission, falsely false accusation against him. He further submitted that from the statement of the FIR, it was to see that no offence has been committed with the filing of the FIR. He further stated that the petitioner also belongs to the community of and question of ability to him in the name of community of the rights. However, he is ready and willing to cooperate in the case if he is granted with the privilege of interim peer resident. Mr. Waterpool submitted that the CTP will like it, and according to the call for the case. That's what we do. Okay, you'll be under interim protection.
My lord, my lord.
Appear before the IO
I am
7 days
My lord.
and cooperate immediately.
My lord, can it be within 10 days, my lord? I have to.
10 days.
My lord.
Within 10 days. Yes.
My lord. Highly obliged.
Yes,
Hello.
Dr.
On 38 minute, 3080.
Highly obliged.
May I please, Lordship? Lordship, this
You
is-
said that there are some
No, there is page 2, Lordship, only one word I have missed now. Page 2 top, Lordship.
Page
In the,
2.
In the
Yes.
court of additional, what I have missed, Lordship. Page 2, second line. Pending before the court of additional is missed. Other has been.
additional chief judicial
Yes,
magistrate.
yes. And pair person is correct.
Let it be, we call for it.
No, Lordship. Petition is that let him know. Case is charge sheeted as someone issued to me, and that is fixed on 6-8 to appear before the court of additional session in a PRC case. And section is under 384, Lordship. I apprehend that if I appear before, I may be behind the bar. Other case is charge sheeted, Lordship, charge sheeted. And someone is issued against me, that is fixed on 6-8, Lordship. Yes, Lordship. So simply I protection will be I am appearing, Lordship.
What is it?
Well, in this
Charge sheeted-
charge sheeted case.
Charge sheeted, Lordship. Someone issued to me, yes. Simply, Lordship, make it. PRC case, Lordship.
You were shown as an absconder.
No, Lordship. It was not also. But 40 notice is given. I have cooperated the IO. Thing is that I may think as far as I can know. So I
What he is saying?
no,
You have been charged in this case or not
that,
yet?
that's charge sheet, Lordship. My name is there. So I received the summon from the court, and that is fixed on 6-8 to appear before the trial court.
Very nice. Then.
Yes,
So
sir. That
let
is
him
the thing.
appear before the trial court.
Yes,
Already
Lordship.
someone issued, my lord.
Yes, Lordship.
No, you are shown as an absconder.
No, Lordship.
Why he is apprehending? I don't know.
Yes,
Okay.
Lordship.
See, why he is apprehending?
Already search sheet submitted, someone's issued to him. Well, first let him appear before the trial court.
Yes,
my lord.
Lordship.
And it is case is under 384 only.
Yes, Lordship.
Yes,
That is-
ma'am.
Mr. Tribal, isn't it? 384. Then? But have you annexed this charge sheet here?
Yes, the charge sheet
Have
is.
you annexed this charge sheet?
Yes, Lordship. Yes, Lordship.
In which page?
Page 18, Lordship. 17 is the translate copy, Lordship. So page 17, bottom I have explained. During investigation, after recording the statement of witnesses, case is made out under section so and so. And that would cooperate during investigation.
At this stage, there is no apprehension, my lord. Let him well abide by the summon issued by the trial court. Ma'am.
There is no apprehension of your error, in fact. You appeared before the error.
Yes, sir.
That
Yes.
you know.
Yes.
Because in the charge sheet
Charge
also
sheet
is
is-
very clear that
Yes.
you, after 41A, you appeared
Yes, yes, I
and they
appeared.
cooperated and you are not arrested. That's
Yes,
why.
Lordship.
Considering this aspect, definitely
Yes,
it will be released on bail, I think. Lord Thakur,
Yes, well, at this stage, AB, my lord, while someone's issued, my lord, asking him to appear on a particular day. At this stage, my lord, this anticipatory bail application, my lord.
and he is not shown as an absconder also.
Yes, my lord.
You are not shown as
I
an
think
absconder.
maybe issued, my lord, as in view of that summons, my lord, let him appear before the trial. Yes, my lord.
So when date is fixed?
6-8, Lordship.
6-8.
Yes.
Appear, it's
Yes,
okay.
sir.
Because against, I mean, in the charge sheet
Charge sheet,
also,
yes.
your cooperation is also
Yes,
there.
recorded.
Yes.
Had Mr. T.K. did only counsel for the petition, put our number. And also for Mr. P. Water, it is, this is an application of the constituents, which is just a second. For it to be an application, for it to be an assessment. Yes, Mr. Day submitted that the case has already charged sheeted under section 304/506 IPC, and presently the same is pending for additional chief judicial.
Yes, sir.
Additional CTM Bongaigaon, and case is registered as PRC case number 104 of 2024, which is fixed for April 8, 2024. Summon is already against the present petitioner. However, he is representing a case, and hence the present petition, and hence the present petition will file seeking pre-arrest bail. Next, Mr. Waterford submitted that the present accused petitioner is not shown as an absconder in rather casted, and he was, and the learned trial court below issued no summons to the present accused petitioner for his evidence, and hence he can accordingly he may appear before the learned trial court below with an appropriate application for him. Next paragraph. Hearing the submission made by the learned counsel for himself. This and after the case report, it is seen that a summon was issued against the present petitioner, asking him to appear before the learned court of National City of Bongaigaon on 16th. And further, from the charge sheet, copy of the charge sheet will be annexed along with the petition. It is seen that the present petitioner you are Pranjit Ghosh?
Yes, actually I am Pradeep Ghosh. His name is wrongly written. Pilot, I am Pradeep and pilot.
That he also cooperated the IO in the investigation of this case and appeared before the IO on receipt of after receiving the 41(1) case there notice. As it is seen that there cannot be any application of arrest in connection at the present, and hence I do not find it proper to extend the privilege of the display to the present. And he is, and the petitioner is directed to appear before the learned trial court with an appropriate application for bail, which may be considered in accordance with the above petition.
Yes.
Lordship, 482 petition, my lord. The petitioner is seeking transit anticipatory bail, my lord, in connection with Bangalore City Electronic City Police Station crime number 02/2024, my lord, in the state of Karnataka. Now, my lord, before coming to allegation, my lord, I want to place the background of the present petitioner, my lord. He is a businessman, my lord, and for his business, he is regularly paying the GST return, my lord, and also the income tax, my lord. Page 11, my lord, kindly see what is the amount he is paying, my lord. Page 11, my lord. Is Annexer 1 series. For the period, my lord, for the year 2021, period March.
This prayer is for transit bail, my lord. Why your lordship will go into the details of all these allegations against us? So for a particular period, my lord, only for a particular period or for a period of, my lord, till his appearance for obtaining, my lord, bail from that court, my lord, only for a particular period that can be granted, my lord, without going into all these.
Yes, my lord.
So this is a case from Bangalore.
What happened, my lord? His bank account was hacked.
Serious offenses, my lord.
His bank account was hacked, and on his request, my lord, his account now blocked. but the case is registered at Bangalore in different states now. And he is cooperating with the bank authority, my lord. Now he is willing to, my lord, approach the jurisdictional court. Till then, my lord, he may be allowed to.
So what is your prayer? Prayer is
Your lordship, how your lordship will grant interim bail my lord, for an indefinite period, my lord?
This is why I'm
For a
saying
limited period, my lord. For a limited period.
it is a fancy bail, not an interim bail or
Yes,
whatever
madam.
kind of bail. And your prayer is a bit defective prayer. You are praying for PLS bail from this court only. He can file an additional, I think, by correcting the prayer code.
Yes.
Then only it will be.
My lord.
Okay. They are listing it on maybe on month 29. 29/6 will do or 29/6?
26 or 29?
Huh?
26 or 29? 29, my lord.
29/6. This month? 29.
This month.
It's not 29. And after he by the addition.
Obliged.
May I please, your lordship. An application under section 482 of BNS, your lordship. Allegation, your lordship, CA or RPUP Act, your lordship. In this case, your lordship, FIR page, your lordship, kindly see 8. This is the FIR, your lordship.
Page 8.
Page 8. On the basis of information, your lordship, ASI, your lordship, information from reliable sources that some stolen railway materials are kept concealed in the escape shop of one Shahjamal located at Anandanagar, your lordship. Some stolen has been concealed and kept, which is found from your lordship, scrap materials from Shahjamal, your lordship. And in this case, your lordship, one accused, your lordship, who is the manager, he has been arrested, your lordship, and thereafter the police produced before the railway court, and thereafter on the same very day he was released on bail, your lordship, as per page 13, your lordship. Page 13. On the production date he was released on bail, your lordship. Some scrap materials has already been recovered, your lordship. Approximately value, your lordship, 600 or 800 perhaps, your lordship. In this case, your lordship, Shahjamal, on that day occasion, your lordship, he went to home office permanent residence of some urgency, your lordship. Accordingly, in absence of petitioner, your lordship, he had appointed, lordship, a person namely Qasir Ali, who has been arrested and thereafter he is released on bail, your lordship. Being a shop owner of dam, your lordship, that is the allegation. In absence of, is running the business of Qasir Ali, and Qasir Ali released on bail, your lordship. And police is searching, your lordship. I have no knowledge about the scrap materials. On that day, I was not present, your lordship, in the scrap shop, your lordship. So ultimately, your lordship, scrap materials has already been recovered, your lordship. Perhaps, your lordship, further investigation may not be required at all, your lordship. Any condition, your lordship, the petitioner can go on interim protection, your lordship, and cooperate the trial investigation agency, your lordship, authority. Scrap materials, failure materials, as per seizure list, your lordship, 9, one fan, cable wearing, your lordship.
He is saying regarding the value of the property, around 600-700. One fan and copperware total 1695 cm, almost 56 feet. Copperware is very costly.
Approximately.
And these scrap owners are helping the thief because of this cycle are going. Theft, they are bringing those articles and sold it in the scrap. This cycle is going on only because of this helping by the scrap owners. Now, yes, the manager already received on bail, but he is the owner.
He is the owner.
So without the knowledge of the owner, nothing will happen. Their involvement is there, and this time this is charged by the police, and this cycle is going on.
On that day, he was not present, Your Lordship. FIR says, Your Lordship, page number 8. Early, I am reading, Your Lordship.
Not present in others, but under your guidance, is all this.
No, Lordship. On that day, I am not present. Whether the
Yes, all these things were not only on that day. It's not a case of only one day.
One day it happened, and police came.
You are doing this business. But there,
washing materials, Your Lordship. Wash materials, Your Lordship.
Wash materials,
Your Lordship.
How can you say such even meters of 50?
And as per release order,
how can it be termed as a waste material? Copper wire, such kind of
seized
as a waste material.
Seized from scrap shop, Your Lordship.
Yes, those were sold. I mean, sold into that your scrap only.
Any condition, Your Lordship. I am cooperating the investigation agency, investigating authority, Your Lordship. Ultimately, materials has been recovered, Your Lordship. Not my position, Your Lordship. On that day, I am not present, Your Lordship. As per I have narrated, Your Lordship.
From his scrap shop, he is the owner. From his scrap shop, so he is the owner. From the
on that day, I am not present.
You know that. Okay, we'll be content with interim. Let us get appear.
The 8th of August.
Publish.
Well, in this case, my lord, I was, my lord, shown a rest in this case, my lord.
It is 21. Most probably NCP is there, no?
Yes, my lord.
Let them come. NCP covered.
I want.
I said.
Yes.
Yes. Keka was there.
Yes,
no. Just we are trying to inform.
Only one thing is that, my lord. Yesterday,
you have been a long.
Yes, my lord. Mohit Hosai, Mohit Agarwala has been distinguished by our High Court and as well as, my lord, there is a judgment. Very good. I want to place that judgment also.
See. Let them come.
Yes.
Let them come. We're just trying to.
Yes, it's fine. One thing is that I have a case in another court also. If I am not present, I may be accommodated at that time.
She is there. Come.
Dr. Masini will come. He is on legs in court number 17, Lord. He will come, Lord.
We also have another matter in court, other court.
In court number 20, my lord. In court number 10, my lord.
Lordship, I will inform them, Lordship.
So, how can it be accommodated?
Yes, my lord. I am there, my lord. I am very much there if he is come, my lord. Only thing, if at that time when he come, my lord, I am not there, my lord. I also may be accommodated for some time, my lord.
Definitely accommodate.
Yes,
no question of not
yes,
accommodating you. So we will inform you when he comes.
No, my junior will be here, my lord.
Here. Okay.
Yeah, I will inform them, Lordship.
Okay.
Highly obliged.
May I please, Lordship?
Yes.
In this case, my lord, the pendency of the case in the London trial court, my lord, petitioner filed a petition, my lord, on 25/7/2022, my lord, with a prior to sending the exhibit 1, that is the disputed check, to the forensic laboratory for obtaining the opinion. What is the exact age of the ink which is used in the check, my lord? That was rejected, my lord. Thereafter, my lord, petitioner filed revision petition, my lord. That petition also rejected on the ground that, my lord, only, my lord, delayed the case, my lord. That is the ground, my lord. The ground is case, my lord,
Only
21. Case 21, my lord. The ground of
Order is
rejection.
21.
Yes. Case
My lord,
21,
earlier
my lord,
in this
last.
case, my lord, this matter is, my lord, wrongly listed for motion. Earlier, my lord, notice issued and called for records on 6/5/24.
No.
Ayubali and others, no.
Ready for a অনুমতি করা নেই। না।
Order 6/5/24. And my lord, NIX case, my lord.
NIX. Notice was not issued, my lord. Only
Not
on the
yet
date, my lord, last occasion, my lord, the court is directed to, my lord, produce the deposition of the petitioner, my lord. That is, I have obtained, my lord.
It's not such kind of order. We are on item number 7.
6.
6. Oh, yes, here too we don't have any, we have not seen any such kind of order. We are asked to collect the PWs.
Yes, my lord.
It's not here.
Yes, that is not, my lord, orally, my lord.
It's not reflected here, and the
Yes, my lord.
in fact nothing has been reflected
Yes.
in the case.
Yes.
Nor there is any prayer for direction for issuance of notice.
Yes.
Also it's not there.
And not reflected in the order, my lord.
So we are issuing notice here first, na?
Yes, my lord. Issue notice, my lord. In the meantime, my lord, impugned order may stay.
No, by two courts they were concurrent findings by the
Yes.
so
Concurrent
better not
finding,
to
my lord.
issue.
Similar issue, my lord. Similar issue, my lord. Decided.
And what we will not face any kind of problem because it's a prayer for only for the FSL that was
Yes, my lord.
Otherwise,
That was rejected, my lord.
Yes.
A similar issue is decided by the Supreme Court, my lord.
No, it's okay.
In the case of
Similar
Nagapur.
issue is okay, but the question is we are issuing notice first.
Yes.
Here. Issue notice Koidok, and as per you, if any direction was there for production of the PWs, I don't know. Here it's not there.
Yes.
In the order, there is no reflection.
Yes. Not
So if you suggest that we can also call for the scan copy of
Yes.
the case check out, let us see what is there. Otherwise, you have furnished the orders are there.
Yes.
It's okay. Orders are already there. But still, if for any reason PWs are needed, then in that case we can call for the case scan copy.
Okay.
Issue notice to the respond number to registered area as well, and also call for the scan copy of the LCA. So it can be listed after 2 weeks or 3 weeks.
Short date may be given, my lord.
After 2 weeks, then?
Yes.
List after. Notice. No formal notice is required to be issued number of and call for can complete their picked up.
May I please also? My lord, earlier status report was called for, my lord. Whether I am discharged or not, your lordship, and as per the earlier order, your lordship, I approached the session court, your lordship, and had a petition, your lordship, but the case fixed on 29 again, your lordship. 2 or 3 dates already have been taken by the session, learned session court, your lordship, for discharge me, your lordship. But my lord, the case is that, my lord, to the...
We have already filed your prayer for discharge.
Yes, my lord.
Now it is still pending.
I think it's
not still pending, lordship. It was taken up on 27/6/24. Before the trial court, lordship. Discharge petition, lordship. 27/6/24. On that day, lordship, the hearing could not be concluded, lordship, because of paucity of time, as has been reflected by the order, lordship. Now it has been fixed on 3/7/24.
3/7.
But what has happened on 3/7/24, that is not up to date. it was also fixed for consideration of charge on that day.
But my lord, nothing has been recovered from me, lordship.
Discharge petition is pending, lordship. So we'll have to know the status.
But my lord, I am approached the court, your lordship. I will be appear on that day, your lordship. As per my information, your lordship, on 29/7/2024, the case has been fixed, your lordship. So on the same day, your lordship, I will be appear, your lordship, for case the trial, your lordship. Whether I am discharged or not.
So let the matter come up after 29/7, lordship, with a status report. That will be the best question.
Your discharge petition is still pending before the London Trial Court.
Yes.
And most probably it is also part heard.
Yes.
Because hearing could not be concluded.
Yes,
so
yes.
it is part heard.
Yes.
So let a date be fixed after 29/7 so that we can know the result of your discharge petition. Then only we can.
Yes, my lord, but I am already on 6 months, your lordship, behind the bar, your lordship. On 78 days already.
Commercial quantity, lordship, charges has not been framed.
No charges? Oh, yes.
Charges
Oh,
has not yet been framed.
so commercial.
Yes, sir. Commercial
Quantity is commercial, your lordship. But as per Caesar list, forwarding report and my lord, FIR, lordship, nothing has been found against me, your lord. So that's why
Case
earlier
is
what
considered under which section?
charge sheet 21C.
21C.
22C.
22C.
Sorry, 22C.
My prayer is that, your lordship, I will be appear on that day, your
Cannot
lordship.
say, but
Any condition may be
is there, 29 is there, so let us see.
But on earlier order, your lordship, the honorable court said that I will be considered, your lordship, today, your lordship.
You will be considered.
You will be considered, your lordship.
It's the commercial quantity we
Yes,
have to go through these things, otherwise how can it be considered directly? It is a problem.
But I undertake I will be appear, your lordship, on 29.
Your undertaking is okay, but heard Mr. You are Mr.
Yes, Islam, your lordship.
Heard Mr. S. Islam, the Learned Counsel for the petition. And also heard Mr. D. Sharma, the Learned PP appeal. Scan copy of the LCR has already been received. However, it is submitted by Mr. Sharma that as per the from the LCR, it reveals that on 27/6/2024, case was for charge date, though it will not be completed.
On that day, lordship, the petitioner filed a petition under 227 for discharge on that day.
So and so, and on that day, the petitioner filed for discharge under section 270 and next date was accordingly fixed for hearing on 3/7/2024. But on that day, it did not completed. And as submitted by Mr. Islam, the date of hearing is hearing on discharge was fixed on 29/7/2024. So considering the entire aspects of the case, I find it proper to call for a present report of the case, and it may where the status of the case be called for. At least the matter according to where it can be listed.
Second week of August.
Normally date will be fixed, your lordship, after 29. Your lordship.
Yes, obviously after 29 we'll fix a date.
Lordship, that will be 6th of August.
6th of August can be 6th of August. We'll just try to collect the present status after 29/7.
Must have been.
May I please, your lordship? Here on the last occasion, a report was supposed to be called for regarding the present health condition of the accused petitioner. And lordship, I am on the ground of long incarnation, and in this regard, I have two judgments to place before your lordship. One is of our own High Court, another is of the Supreme Court. Lordship, may kindly permit.
What is your period of incarceration?
Here I am there since the day of my arrest, lordship. I was arrested on 609 days, 12/9/2022. I have been arrested. 12/9/2022. More than it is more than 2 years. Around 2 years. I am placing one judgment of this honorable court. The Lordship may kindly have a look into paragraph number 24, 25 and 28 of our own High Court. Paragraph number 24, Lordship, which says, Lordship may kindly appreciate. The Supreme Court of India in Muhammad Muslim Hussain versus State of NCLT, reported in 2023 SC Online, has observed that grant of bail on the ground of undue delay in the trial cannot be said to be fettered by Section 37 of the NDPS Act 1985. So, that part your Lordship will kindly see. In case of Ravi Prakash versus State of Odisha, reported in so-and-so, it has been observed that the apex court, that the prolonged incarnation of generally militates against the most precious fundamental rights granted under Article 21 of the Constitution. In such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act. Now, Lordship, kindly have a look into paragraph number 28, Lordship. In Nitesh Adhikari versus State of West Bengal, the apex court granted bail to the accused facing acquisition under 21C of the NDPS Act 1985 on the ground of incarnation of 1 year 7 months. I am almost there for around 2 years. Charge has been framed. Trial could not commence because the other co-accused is absconding, which is definitely not my fault, Lordship. This definitely cannot be said to be my fault. And the other accused, he is the owner of the vehicle. He has
charges framed then if other accused is
he was supplementary charge sheet was filed. Initially, my lord, charge sheet filed on 30/11/22 against the 2%, against the driver and the helper. Driver and the helper. Present petitioner is the helper of the truck. And in that case, charge framed on 25/23, my lord, against the present petitioner. And then supplementary charge sheet filed.
25B.
25/23, my lord. And before filing, after filing of the supplementary charge sheet, Lordship will kindly see, he appeared before the court, asked for the Jimma of the truck. The Jimma was granted, but that the accused number 3, the owner. Jimma was granted, but Jimma was not given on the ground that he surrendered before the court. And now he is pleading. Since he is pleading now, the trial has come to a standstill. And they are, Lordship, they are people from the village, doesn't have any literacy, doesn't have any knowledge. On that ground, and Lordship may kindly see, there's one Supreme Court judgment. This is of 2023 live law. Kindly have a look into paragraph number 4, Lordship. As regard to twin condition contained in section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition states complied with. So far as the second condition, reformation of the opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in the custody. The prolonged incarnation generally militates against the most precious fundamental right granted under Article 21 of the Constitution, and in such situation, the conditional liberty must override the statutory embargo created by 37(b)(2) of the NDPS Act, which our court is also reappreciating, Lordship. And our court's judgment, Lordship may kindly see, is the recent most judgment. It is in 26/6/2024. Very recent most judgment. So I should pray that on any ground, Lordship may kindly set me at liberty, because I have already spent a long time and I am simply the helper. Nothing to do. Yes, court will, for the purpose of securing my presence, court may impose any condition. Any condition court may impose. I am not on that.
Now, what about the other status of bail, Mr. Potter?
My lord, regarding now, my lord, case supplementary charge sheet filed against the owner of the vehicle, showing him as absconder, one Ranjit Singh. So now, my lord, till trial not yet. Regarding the, my lord, report of the death medical report, your lordship has passed the order on 18/7/24. Regarding that report, my lord, I have not yet received, my lord. Whether, my lord, any immediate operation is required, needful or not, my lord. I think that report not yet received. Otherwise, from the my lord report of the jail authority, it seems that my lord, if any immediate operation, if any required, my lord, from that it seems that my lord not at all. Otherwise, my lord, while your lordship has passed an order, but regarding that, my lord, I have not received any such report. And regarding the my lord, he is the my lord, only argument is advancing is that my lord, regarding fundamental right of the my lord accused person is violated by violating Article 21 of the Constitution. My lord, here he is the helper of the truck. Without having his helping hand, this type of offence, my lord, never been committed by the all the my lord, owner of the truck, driver of the truck.
From where my brother is saying
I am going to say, my lord, regarding violation of fundamental right. My lord, since the time we are reading the Constitution, my lord, I may be wrong or not, I do not know. Fundamental right of no one is absolute, my lord. If you want to enjoy your fundamental right, then you should not violate the fundamental right of others. By my lord, in itself, my lord, prima facie, by involving in this type of NDPS offences, you are violating the fundamental rights of my lord, thousands of peoples, my lord. By violating fundamental right of peaceful life of the my lord, various families, my lord. So it cannot be the fundamental right of this type of NDPS accused person cannot be equated with my lord, common citizens, my lord. So my lord, at all points of time, by placing Supreme Court, my lord,
this is the authorities of the apex court. How
Yes,
can
I
my
am not
brother
going
make-
against the
how
authority
can my
of the
brother
apex?
make such a submission when this is an authority of the apex
My
court?
lord, he has wrongly
authority
submitted,
of
I am not
our
going-
own court. I have not wrongly submitted. I am on the authorities.
My lord, I am not
I have
going
not
to
made any submission of my own.
My lord,
When there is already a authority of the apex court, authority of our own court, how can my brother go into the question of reasonable equality? Here the question of reasonable equality does not come.
He,
From the
now he
question of
wrongly
reasonable
submitted that
equality
I am
comes.
going against the my lord authorities of the Supreme Court. How my lord can it be possible for me to go against the authorities of the Supreme
From
Court?
where I have
My lord, I am just pointing out while he is arguing against the fundamental right by showing all these judgments. So my lord, there are also other judgments also, my lord, regarding since the time we are reading the Constitution, one thing is very clear: that fundamental right of no one is absolute. No one can enjoy their fundamental rights if you by violating the other right of the other citizens, my lord. And here in this type of case, I am just saying I am not going against the my lord authorities of the Supreme Court. Definitely, my lord, we are bound to follow the order of the Supreme Court, whatever Supreme Court has passed regarding in particular facts and circumstances of the case, my lord. But here, while you are saying that about the fundamental right, so maybe at that point of time some arguments may not be there. So while you are, my lord, trying to protect the let me say, while you are trying to protect the my lord fundamental right of the accused person, where the fundamental right of the my lord other common citizens, you are, my lord, violating the fundamental rights of all the my lord, various, my lord, all the common citizens, my lord, various peaceful life of the. Is it not my right to, my lord, lead a peaceful life, my lord?
First of all,
This
let's
is the
submit to
argument,
what
my
my
lord.
brother has just said. Fundamental right vis-a-vis should be read with the directive principles of the state policy. If I am to enjoy the fundamental rights, I am to abide by the directive principle of the state policy. I am not a state that I will protect the fundamental rights of the other citizen. Neither I am a state that I can hamper the fundamental rights of the other citizens. Directive principle of state policy is neither the hand of the state. Here these are the authorities which speaks of the commercial quantity. And Constitution says that if I am to enjoy the fundamental right, then I have some fundamental duties. What are those fundamental duties that are enumerated? My fundamental right is not coming into the way of fundamental right of the citizen. Have I asked them to take the drug, Lordship? Or I am a trafficker? Is it been proved that I am a trafficker? What my brother is submitting? Being a prosecutor, you should object. Nowhere
This
written.
type of argument is, well, this being a
This
prosecutor,
type of
don't
argument-
make this type of argument. I am just
You
pointing
you
out
are you are unable to
you are
bring the
also-
medical
you are
document.
also-
So many dates have been given to you. You have not been able to bring a single witness. Your prosecutor, your investigating agency has wrongly shown him as an absconder. Can police show him as an absconder, Lordship, in the charge sheet? Does police have the power to show absconder without abiding by 83 and 84? There are judgments of our own High Court. Shall I remain there for infinity days? Days infinity?
No, regarding my lord, in this case, my lord, prima facie, my lord,
Lordship
it
will
seems-
take Lordship's call. I am leaving it
My lord,
up
I
to
am
your
not
Lordship.
objecting, my lord. I am just pointing out to your Lordship while argument is made regarding the fundamental right. In many cases, my lord, argument is going on. So for which
Not in many cases. Here the judgments of our own High Court.
Yes.
Let my brother say that this judgment of our own High Court is not proper. Then I will agree to it.
My lord, regarding
Our own High Court judgment. Am I not entitled to a parity of this judgment?
My lord, regarding the present case, your lordship, yes, he is a helper of the my lord truck, and my lord, yes, my lord, regarding that argument, yes, in this case, my lord, till now trial not yet started, and because my lord, that my lord, owner of the vehicle was my lord, later on supplementary charge sheet, my lord, on 25 yes, and regarding long incarceration, your lordship may consider, my lord, that is my lord up to your lordship, my lord. And while my lord he is submitting submission is that only because he is a helper, my lord, that cannot be a my lord argument that only because he is a helper for which my lord your lordship may allow him to go on bail. That should not be my lord good argument.
I am not on merit lordship now because trial has not commenced. Therefore, I have nothing to give any comment on the merit of the case because trial has not commenced, and it was their duty to commence the trial. It is my fundamental right to a speedy trial. That is also been violated. And lordship, I kindly see the judgment in which our own High Court has given the bail. It's a matter of NCB, not of the state. NCB is well known for their high quality of investigation. In the NCB case, this bail has been given, which I am relying upon, of our own High Court lordship. Investigation has not been done by the state police. It has been done by NCB. Even then, the court has given the bail. Reason why? Long incarnation. And what was the period, lordship will kindly see? Here, the period was 1 year, 7 months. Period He was there for 3 years, 8 months. And if your lordship wants to give them any chance in producing the medical document, that is up to your lordship.
Otherwise, my lord, already one jail authority's medical report is already available, and my lord, considering long incarceration, that is, I will leave it to your lordship, my lord. And because yes, trial, my lord, not yet started since my lord 12/9/22. That ground, my lord, on the basis of the my lord authorities of the Supreme Court, I will leave it to your lordship, my lord.
Deep level.
And my lord, only because argument at all time, my lord, regarding fundamental rights. So, my lord, I am just pointing out that fundamental rights of common citizens and, my lord, these type of accused persons cannot be equated, my lord. That is only my argument. While
deep level.
Right, please, your lordship. Hello. 439 application, your lordship. I have been arrested on 19/5/2024, your lordship.
95.
Lordship.
So, already submitted. Just now I have come to know, madam. Charge sheet number 22/24, dated 9/7/24. Otherwise, earlier CD was there. I just sent for up to date CD, madam. 15 years here.
Yes.
22/24,
9/7/24. So you are in custody since when? 9/5?
19/5/2024, your lordship.
Submitted by Mr. Devan that the testimony is behind the person's 95/2024. Hence, considering the interpretation in the case. However, my law will start up with Mr. Devan, we have recorded your submission that he is in custody since 19/5/2024. That
my
considered by the Ranad Trial Court.
lordship, my further submission, your lordship, that on being submitted to lordship, the appropriate petition, your lordship, because since I am for long 19/5 have been registered, although charge sheet have been submitted, your lordship. On filing the appropriate petition, Lordship, my bail prayer may kindly be considered.
Yes, yes, I have already. And your submission that he is in custody since 95, that has also been received.
Lovely.
So I am for the informant Lordship. AK Azad.
Oh, you are for the informant?
Yes.
Heart informant good. Your name?
AK Azad.
Mr. AK Azad.
Yes.
Heart Mr. AK Azad or Koridibo, London Council for the informant. Mr. AK Project. Okay, I'm good.
Most of
Lordship, search-seated case, Lordship. Scan copy was called for, Lordship. Lordship, I have also got the certified copy of the statement. She has exonerated me, Lordship. This is the copy. I have also given the statement given to the police also. It was a copy supplied to me. It was taken on 19/7. 83 days in custody. Initially, it was registered under section 365. Later on,
And have you issued notice to the other side?
yes, Lordship. Lordship, notice was issued. He is also 21 years. Lordship. Kindly allow me to go on.
Steps for issuance of notice to the respondent number 2 has not been received by the registry till now.
Lord.
Have you taken steps?
Probably I have given the
No matter,
steps,
that's why I'm-
Lordship. If a Lordship doesn't, they want to withdraw this petition, they will try the petition in the lower court, Lordship.
You want to withdraw this one?
Yes, sir. If today is bail is not, any order is not.
Today means it's okay, but the question is that
I've given us
number 2 is not here for us.
Lordship.
And the office note reflects that you have not taken steps.
Lordship.
That's
On the last day, 28th, Learned PP said I will inform the IO, Lordship.
Okay, do you have any information?
He was not there.
In absence of steps, also we also cannot. We have to.
Copy was there with the Learned PP also. That's why we thought that
Thakur was there. Thakur, yes,
Botaku probably brought him as Zahan was there, Lordship.
As Jahan was there.
Yes, Lordship. On the 28th.
On 28. But 20 was the first date.
First
How
day.
it can be
On that day, we were told to take steps, Lordship.
yes, obviously.
Yes, sir, Lordship.
You have been asked to take steps for
Lordship.
the number 2.
Yes, Lordship.
I don't know whether you have taken or not, but as per the office note, they
I
have
have
not received.
asked her to do a civil inform the IO through WhatsApp also like that. Copy to the assembly.
কোথায় কোনে কাক WhatsApp করবে?
Probably not given Lordship, maybe.
মানে WhatsApp will come when you take steps, then
Yes, Lordship.
definitely
Yes,
the
Lordship.
additional PP may take an initiative.
In that case, I have instruction to withdraw this
Withdraw
petition.
this one, okay. And this certified copy will be required by you?
Yes, Your Lordship, it may be required, Lordship.
It will return for you. Okay. So as per you, your name is not, you are not been implicated. Then it will be very good case for you only. It will be the-
Otherwise, if that part is given, I am exonerated.
But the question is that after the Deepak Nayak case, we have to...
Yes, yes, Your Lordship.
Minimum formalities has to
Yes,
be
Lordship.
followed. That way. Anyway, then if you want to withdraw, we'll pass you.
Yes, Your Lordship. I have instruction, I have been instructed.
Instructions of the council of the institution of this kind. So it's submitted as supposed to be the same. However, the submitted after the scan of the indication, but from the office it is that the state is not yet received by the registry against it. However, considering submission made by the London Council, the case is accordingly put up. Okay, it will be disposed of on withdrawal.
Yes, on with them. Deeply, AK Sekia.
When- when- Yes.
AK Sikya.
हाँ, AK
Sikya.
AK Sakya.
Deeply obliged.
Oh.
May I please, Your Lordship?
Yes.
Lordship, in this case, I'm here for co-accused, Potibul Hawk. So, nothing, no suspected drugs has been recovered from my possession. I'm at Rongia. And the prime accused, Amir Khan, is a occasional visitor.
It is yellow.
Okay. Yes, you are the occasional.
Prime accused, that is Amir Khan, is a occasional visitor of my lodge. I have a lodge at Rongia. So my name has been falsely implicated and stated by the prime accused. On the basis of the statement of the prime accused, I have been arrested and I have been behind the bar since from 54 days. That is 31st May 2024. My Lordship, nothing has been recovered. No suspected drugs has been recovered from my possession. My Lordship, Annexure 3, Annexure 4. The seizure list does not contain any suspected drugs, my Lordship.
From your point.
Yes, my Lordship. Only on the basis of the statement, the name suggested by the prime accused, that is Amir Khan, I have been behind the bar, my Lordship.
Yes.
Kindly accept my bail petition.
Let them what CD revealed here.
Lordship, the case is still under investigation, Lordship. And as Lordship has already seen the FIR and forwarding also, Lordship, 604 grams of brown sugar, heroin, was recovered, Lordship, from one person whose name is Amir Khan. And he was supposed to deliver his drugs, Lordship, to the present petitioner, Lordship. And thereafter he was arrested. Investigation is going on, Lordship. His bank account details are being sought for. CDR analysis of mobile is going on, Lordship. And also the FSL report is still pending, Lordship. So, Lordship, this is at a very preliminary stage of investigation. Lordship, I will say, Lordship, at this stage the bill may be rejected, Lordship. He may be allowed to approach the court at the appropriate time. Only 54 days.
My Lordship, the suspected drugs was supposed to be delivered to Rumia at Mutibul Hawk. So, if my petitioner is supposed to be accused in this instant case, then something has to be recovered from his possession.
And we still have 180 days, Lordship. Total period is 180 days. Today is 54 days.
My Lordship, since seizure list does not contain any suspected drugs, then those sections, whether it is B, C, A, whatever it may be, but nothing has been imposed, my Lordship.
Yes, Mr. Lipa.
Kindly accept this bail petition, my Lordship, since my petitioner is a Indonesian.
And a huge quantity of brown sugar, no? The brown sugar has been alleged to have been recovered from the Kuwait.
Yes.
Your position may not be there, but the
other aspects are
conscious, constructive, whatever is
Yes.
there, I think that's the main issue. But it's okay. But Mr. Rakesh.
Rakesh Dhar.
Rakesh. Heard Mr. Rakesh Dhar, and also heard the Sharma, the petition of KP. This is an application of section 2 it is submitted by Mr. Dhar that the present is innocent and he has been falsely implicated in this case. He got arrested in this case only on the basis of the statement made by the witness and not personally present. He is behind the persons last 54 days and hence, considering his length of detention, it would be he is ready completely high for that next plan, contact Mr. He has submitted that from the present the got arrested which case was supposed to deliver the drugs to the present petition but on his way he got arrested and the result of the convicted. Further, petitioner indicated that it is preliminary stage of investigation and the IO is get CBI analysis report as well as and hence he really thought that it is that the bed for the present petitioner will be considering its the October conference and have also delayed the case diary and it is said that the business investigation and the IO is to receive all the comma CJ analysis report which are from the concern in the same time it is seen that the statement of other witnesses are yet to be recorded in connection with this case. And considering all these aspects of it and the nature of the condition, I do not find it proper to allow the persons to go on bail. Now, because this is a case of commercial quantity and where it is statutory periodic of 180 days. So now 54 days has gone. So there are still the preliminary stage of the case.
My Lordship, 54 days is also sufficient time to investigate.
Sufficient time for other offences, but for NDPS it requires some more time. That's why the legislator has given 180 days instead of 90.
My Lordship, I admit, but nothing has been recovered from my possession, my Lordship.
Yes, nothing has been.
Nothing has been recovered. Only can you see?
That I have seen. So it is disposed of. Your petition stands rejected at this time.
May I please, Your Lordship? Lordship, under custom that gold was recovered, my lord. 50 days in jail.
It has come.
Yes, Lordship. Kindly pass over the matter for time being. My senior will come now. We have just received our case diary, Lord.
You have received your case diary.
Kindly oblige.
May it please your honor. May it please your lordship. Lordship, this is regular bail application, my lord. The petitioners are shown arrested, my lord, on 7/6/2024, my lord. Today is 48 days behind the bar. My lord, the petitioners earlier arrested in another case, my lord, and they subsequently got bail, my lord. In 29, he got bail from the learned court below, my lord. I have the order copy, my lord.
Both the petitioners were
Shown arrested on 7/6/2024, my lord. And another fact is that the petitioners are not named in the FIR, my lord. They were shown arrested on suspicion, my lord. 48 days is behind the bar, my lord. IO has sufficient time to investigate the case, my lord. And in item number 30, my lord, two petitioners, Ataur Rahman and Inamul Haq, they got bail by this honorable court, my lord, by ordinance bench, my lord. I have the order copy, my lord.
So bail is okay. Now here you say in the present case what is it? They are also shown it.
Shown it.
On 7/6 itself.
7/6.
In earlier you want to say that in earlier cases they got already paid.
They can pay.
Yes, my lord. Case diary received, my lord. And these are, my lord, very serious, my lord, organized financial crime, my lord. By using, my lord, by forging, my lord, various, my lord, Aadhaar cards, PAN cards, my lord, and various KYC documents, my lord, they obtain loan from my lord, online method through various, my lord, apps, my lord. And thereafter, my lord, while they paid, later on, my lord, your lordship may kindly, the case diary is also available, my lord. Use case diary, my lord. And this, my lord, accused person in an organized manner, they obtain loan from those financial institutions. And thereafter, my lord, initially to create, in some of the, my lord, cases, my lord, to create, my lord, paid, initially they paid some of the, my lord, installment. And thereafter, my lord, they stop payment, my lord. And thereafter, during verification, my lord, while my lord, in all these my lord bank accounts, my lord, bank loans, while the financial company has not received, my lord, stopped receiving the EMIs, and during verification, my lord, it is found that my lord, those my lord members of the organized racket, how by forging my lord documents of various my lord persons, my lord, but my lord, photograph of they use the photograph of their own, my lord, because for obtaining the online loan, my lord, they will have to be live, and for that, my lord, by affixing their own photograph, my lord, they obtain loan in different accounts, my lord, and initially they find out the my lord that is my lord CIBIL score from by through my lord, there is a method of searching through my lord GST my lord portal, and thereafter they finding some of the my lord individuals from those my lord portals. Thereafter, my lord, by using documents, they also my lord, there are also various techniques, methods how they collect all those documents. Thereafter, by using all those documents in various accounts, my lord, police my lord, investigated the entire matter, and individually all these accused persons, my lord, and they, my lord, brief list also, my lord, collected by the provided by the police, how all these accused persons took loan from the bank in various accounts, my lord, in the name of my lord various other persons, a detailed list, my lord, in all these cases, specifically by the all these accused persons, my lord, and specific list is also available in the case diary, my lord. These are very serious offences, my lord, involving, my lord, these are my lord serious financial fraud, my lord. The racket, my lord, is involved in committing this type of offences, my lord, and this FIR is lodged by one of the financial companies, and my lord, investigation is still going on. At this stage, my lord, only length of detention may not be a good ground for granting bail, my lord, to these accused persons. Your lordship may kindly peruse the case diary also, my lord. There are specific allegations against all these individuals accused persons, and those, my lord, detailed list of the accounts, name of the persons in whose name, my lord, they took loan from the my lord, by through the online method, my lord, all these, my lord, records available in the case diary.
My lord, the main case where they got arrested, my lord, here the 3D indicates that the 467 is not attracted, my lord. And if 467 not attracted, then 60 days is statutory period, man. And already
You were
48
saying on those earlier.
earlier, but I have.
I don't know. There is an observation I have seen that 467 is not the
No. And then
Here,
60 days, my lord. And today 48 days. Only consider this, my lord.
case reports regarding the attribution of 467.
My lord, regarding at this stage, my lord, it cannot be said, my lord, I have not gone for that order. My lord, during investigation stage, my lord, it is difficult to say, my lord, because investigation is still going on. All this, how can I at this stage, my lord, I can say that 467 is not attracted, my lord. Prima facie, my lord, all this section, my lord, your lordship may kindly peruse 467, please. I see, my lord. And this is not the same case in which, my lord, he was granted bail. This is a separate case. He is shown arrested, my lord. In that case, my lord, while passing that order, it may be by going through the, my lord, case diary, may be said that 467 may not be attracted. But, my lord, regarding the present case, my lord, because this is not the same case, my lord. My lord, forgery of valuable security, will, etc. So, my lord, prima facie, these are valuable security. They are Aadhaar card, my lord, PAN card, these are valuable security of an individual, my lord. Prima facie, my lord, 467 attracted, my lord. And those accounts, my lord, are used by these persons, my lord, for obtaining loan, my lord. Whoever forges a document which purported to be a valuable security or a, so, my lord, they are forging the documents. My PAN card, my Aadhaar card, by forging those documents, my lord, by affixing their photographs, they obtain loans. So, prima facie 467 attracted without going into the details of other, my lord, lines, my lord.
Another case where got bail, my lord, the same section attracted, my lord. And the court observed that the 467 is not attracted. Therefore, I am submitting.
Please refer.
That is not the
These persons may be arrested in other 2-3 cases also because they may be habitual offenders. The nature of allegation or the way they committed the offense may be a bit different also. I don't know that at this
Yes,
stage
ma'am.
we cannot say what is the difference. But prima facie, if you see the 467 is outwardly, it cannot be said that 467 is not affected.
Yes.
Because those are the available security reasons for your false documents to obtain the loan, etc. So, prima facie, it seems.
Yes.
My lord,
Your Lordship,
this
may
is-
kindly peruse the case diary, my lord.
My lord, this is 23 case, my lord, 2000. My lord, this is 2023 case, my lord, and these petitioners are behind the bar since 48 days, my lord, and the IO has got sufficient time to investigate the case, my lord. Kindly consider this, my lord.
So during investigation, I also communicated the nodal officer of the Central Bank of India also.
Yes, ma'am. There are many accused persons regarding the present two accused persons. First page and back side is also first page by Dr. Azabul Rahman regarding the present accused. Everything is detailed. Actually. And in the case diary also middle person rightly in detail, my lord, explaining how they committed these offences.
Some of the KYC.
Yes, my lord. KYC
are also
also.
been
Yes.
calculated.
Yes.
But considering the date of detention, my lord, in the shown arrest case, 48 days, my lord, kindly consider it, my lord. With any strict condition, my lord, I will abide by that condition, my lord.
Heard Mr. Heard Mr. Yu Khan, Ilan Council for the petition, and also heard Mr. Report Ilan Intellectual Next by Mr. Khan, submitted total evidence that he attacked what he has attacked what they have satisfied. One is two petitions are there in one case, and in 29 only one petition submitted that he is innocent and he is strongly connected in the other process. He further submitted that the expedition is behind the person's responsibilities from the date of shown arrest, and thus the IO was sufficient time for their custody interrogation. Further, he submitted that in the earlier cases also, they are already granted bail by coordinate of court, considering the fact that considering that in 467 do not know the however, he is really in the corporate IO. In further investigation of this case, it is granted with equity. Mr. Waterford submitted in this regard that the modus operandi of the present accused petitioner is that they created some fake SIM card and other cards, even KYC, loan, etc., and accordingly obtained the loan from the bank, showing the affixing their own photograph, and after collection of the loan amount, even they used to pay the installments, and thereafter they avoid payment of the installments, and thus committed a serious financial fraud, instance faced with custom. Further, Mr. Waterford submitted that from the IO also collected the documents from the bank contract, where from it is seen that they used all these other card, SIM card, KYC certificate, etc., to obtain the loan from the bank, bank in the name of some fake person, and thus they committed a serious case of fraud, financial fraud. Mr. Waterford further submitted that the case is still under investigation, and the custody interrogation of the present investigation may be necessary to unearth some more facts of this case, and accordingly he raised objection and submitted that it is not at all a fit case to bail to the petition. Hearing the submission made by the London Council for I have raised the case diary and submitted that I have collected sufficient informative materials against the present accused petitioner, and sufficient documents are already collected by I during the investigation. However, the investigation is never progress, and considering the nature and seriousness of the allegation, I find that custody interrogation of the present petitioner may be necessary for the rest of the investigation. Also, it cannot be outrightly said that there is no material it cannot be outrightly said that prima facie there is no material to attract 6467 IPC. Next, considering the entire discussion I got. Your petition stands rejected at this stage.
Obliged.
Okay.
May I praise the Lordship? So I'm paying for the first work of the day, Lordship, in this case. Can it be fixed on Monday, Lordship? Thank you. Monday, Lordship. 29.
29, but I cannot say Monday only. Either 31.
31.
Maybe request the president. Thirty-one, sir.
Most of them.
But 31, my lord, petitioner is in interim case diary not received. My lord.
Your interim will be extended in the next year. It did not issue reminder. Interim extended, yes. What happened?
On my lord, 308.
308? 308?
Yes.
Okay.
My lord, both the petitioner appeared before the IO.
Already appeared before the IO. Yes, they were in interim, I think.
Yes.
He is the owner.
One is the owner and another was the owner of the kettle.
One is the owner of the vehicle and another is the owner of the cattle.
Yes. Mukleshwar Rahman is the owner of the vehicle and
Hanif Ali
is the owner of the goods. They have already appeared and submitted the document before the
Hard MS. You are MS?
M. Decca.
M. Decca. The Ghana Council for the Petition also had subsidiary sector. So it is submitted by MS Decca that the accused petitioners have already appeared before the IO. After obtaining the interim order of rearrest, dated 1960 and cooperated with the investigation. They are still ready and willing to cooperate in the further investigation of this case if they are granted the privilege of rearrest. Next, Mr. Sharma submitted the London petition PP submitted in Mr. that would the accused petitioner already appeared before the IO and they cooperated in the investigation and also furnished and also submitted the relevant documents before the IO. Accordingly, he submitted the constituent email indicates that as the conduct of the accused petitions, they may be repairment and the reports. Into 19/6/2020. Okay, your bail will be considered as absolute.
Yes, Lordship.
35 also Lordship, the petitioner is interim. It appears Lordship from the FIR that there was some sort of a monetary transaction between the parties, between the petitioner and the informant Lordship. Subsequently, the informant has also filed a case under NIS Lordship for this. It finally comes to the FIR also. Page 12, no? 12, 16. 16 Lordship. And this is the FIR Lordship. Here Lordship, the main allegation is that the 53 lakhs was owed to the petitioner Lordship. And in that regard, he had given some check Lordship, which subsequently got dishonored, and thereafter he filed his FIR. In the meantime, the informant has already filed a NIA case against the present petitioner. And he has appeared before the IO. Custodial interrogation is completed.
So informant has already filed an
Yes, it is in the case study itself.
Otherwise, you have appeared before the IO.
Yes.
Same order. So, Mr. M. Kolika.
Yes.
Same order group. After submission depot. For this cooperative further, Mr. Sharma, the PP has submitted that during the pendency of this case, the informant has already filed and NIA case against the acting in acting with same order. Okay, your bail order dated 19/6/2024 is hereby made absolute.
Obliged.
In this case diary received, my lord. Earlier, case diary and FSL report was called for. FSL report is not available in the case diary, my lord. Anticipatory bail, my lord, NDPS case. 14.5 kg of ganja recovered from the two accused persons, and during investigation, he is the owner of the vehicle, and from the statement of the other accused person, it reflected he is the person who asked them to transporting all those ganja as per their research. So now police is searching for him. An FSL report not yet received.
Can it be fixed?
On 29th of August, 29th. 13 months.
So in that case, you have to return back the case.
Yes, otherwise I will call for the FSL report. Otherwise, from the statement of the other, till now FSL not yet received. Otherwise, 14.5 kg of ganja, he is the main accused person, the present petitioner. From the statement of the other accused person, can from the investigation also reveal that he is the owner of the Bolero vehicle, which was used for transporting of the vehicle, and how this person instructed the other accused persons to carry those ganja from the Nagaland from a particular place. Those are clearly explained by the other accused person. So now police is in charge of the present accused person.
City received, however, the FSL report is not available in the case report, which may be required. And accordingly, he submitted that the FSL report may also be called for. Return the case diary for, and the highway is hereby asked to furnish the updated case diary along with the matter pay according to 13th will be okay for you?
13 Lord.
13.
Oblige, Lord.
May it please your lordship. Earlier, my lord, case diary was called for lordship. FIR is at page number 14.
Yes, case diary you have received the
Yes,
case diary?
yes.
FIR is that page?
14, my lord. So for the present petitioners are concerned, my lord, they are implicated in the first 3 paragraphs of the FIR, my lord, and rest of the part of the FIR, my lord, we have no connection with that, lord. May I read, my lord? With due respect, I have the honor to inform you that during the time of executing night patrolling duty on the night of 11/6/24, we have come to know from a reliable source that one white color Tata DI vehicle loaded with some stolen cattle was flying from Chotaki village through Salakati Bazar towards Holmara side. On receiving the information, I, under the guidance of IC Salakati OP, and with available staff, proceeded towards Salakati Bazar and saw the said vehicle coming from opposite direction. Accordingly, the vehicle was directed to stop, and while we stopped the vehicle, the driver of the vehicle bearing registration number so-and-so, Hamidul Ali, son of Askar Ali, village so-and-so, could be apprehended. During search of the vehicle, total 11 numbers of male, female cattle could be recovered and later on seized from his possession as per seizure list in presence of available local witnesses, and the seized cattle Tata DI vehicle were brought to Salakati OP along with him for taking necessary action. On interrogation, the accused driver Hamidul Ali, son of so-and-so, that stated that one person Zahirul Islam, this is the petitioner number 1, my lord, son of Saizuddin Islam of Chandiagao under Salakati, has hired his vehicle by fixing an amount of rupees 4,000 and asked him to load some cattle from the house of Nur Islam, son of so-and-so, cow dealer of Chotaki, and to deliver the same in a house nearby the highway of Pakrikal, Sapar of Dhubi district. He also disclosed that before 8 to 10 days, he delivered 6 cattle at Sapor, which were loaded from the house of Siddiq Ali, son of Baset Ali of village Chotaki, received an amount of rupees 4,000. As per his statement, the above noted Zahirul Islam, son of so-and-so, village so-and-so, number 2, Nur Islam, son of so-and-so. Number 3, Siddiq Ali of village Totaki, all are from PH and district Kokrajhar, Assam, are found involved with the occurrence who are habitually doing such illegal business for a long time. My lord, our implication is solely based on the statement of the driver of the vehicle, my lord, and all the cattle were recovered from the driver itself, lordship. And the statement, which is a confessional statement before the police, my lord. And there is no other incriminating material except the statement of the driver, my lord.
Exactly, that is the case, they have been doing this business, lordship, and inflicting cruelty on the cattle, lordship, because they have been carrying these 11 numbers of cattle in a small vehicle without any permit, no medical fitness certificate, nothing even. That was lordship, I leave it to you, lordship.
That is based on the statement of the driver, my lord, from whom the cattle were recovered, my lord. That too is a confessional statement, lordship. And based on that statement, lordship,
the case is registered under which
case is registered under, my lord.
It is registered under 13(1) and 16 of Assam Cattle Preservation Act, as well as 11(1)(d of Prevention of Cruelty Act, and lots of other IPC sections are 380, 411, 430.
These IPC sections will not attract in this case. So far, the present petitioner are concerned, my lord. And also the
411, 413 are, I think, of this one.
Let them cooperate.
Heard Mr. M.M. and also heard Mr. This is an application of section so and so. It is submitted by Mr. Chaman that the present accused petitioners are innocent, and they are no way involved in the alleged offence. However, from the statement made in the application, some allegations are brought against them only on the basis of the statement made by who got arrested in connection with it and from whom the cattle were recovered. However, we are really unable to cooperate the IO in further investigation if they are done with the that from the materials available in the case diary, it is seen that it is from the name of the present petitioners are brought in 85. However, he submitted from the nature of the offence as well as from the available in the case diary. It is read from section 311, 380, 411, 413, 534 IPs. Accordingly, he submitted the release of the second petition cannot be referred for the interest. Okay, you will be granted with the privilege of pre-arrest bail. Appear before the IO within 7 days, both of you, and cooperate him in the investigation of this.
Alright.
There are some other conditions will be also be there, abide by all those conditions.
my lord. Highly obliged, lord.
39 also petitioner is on interim and CD has not been received.
CD not received?
CD not received. So let it come on 22 August.
22.
August.
22 April. Interim will be extended.
My pleasure, Lordship. In this matter, I am on interim and I have duly recorded my statement as per the order dated 3/7/2024 when I was granted the interim by this honorable court. So, as far as my statement is concerned, I was nowhere involved with this entire allegation because of the fact that my name was there because I was the owner of the vehicle. Apart from that, I was not at all involved with the allegation whatsoever. The fact is that I have given this vehicle to one person. His name is Mohan Pegu, and he was involved with carrying of the materials from wine shop because it is a commercial vehicle. So I am just the owner and I have given him for commercial purpose. Now he, on the day of the incident, it has come to my knowledge that one Dinesh Pegu, he was driving the vehicle. So most probably Mohan Pegu was there. He might be there along with him because when the Naga checking, there were two persons, the police have stated that they have seen two persons fleeing away from the vehicle. One was the driver and one was another person. But he was not named in the FI. But just because I was the registered owner of the vehicle, my name was there. Now I am a teacher. I am currently pursuing as a head teacher at 218 number Sonowal LP school at Moriani. So in that particular sense, I have already duly recorded my statement. I am ready to cooperate with further anything is required from my side during the investigation. So after praying to make it applicable.
Sir, my case they received my lord. He is even a headmaster of an LP school. He is cooperating with the investigation. And at this point of time, regarding
but
his
headmaster is doing all this.
yes. Otherwise, we are cooperating with the investigation.
Mr. Dr. Bitu, he done with counsel for the petition. And also heard Mr. Keyboard. It is submitted by Mr. Mehdi that he is innocent and he is no way in the investigation. He is the developer and presently employed. With the teacher office and it's the fact that he is the owner of the vehicle. And he is not aware, and which was given already for commercial purpose, but he was not aware about what has been transporting in his vehicle. However, he has already appeared before the eye after obtaining the interim clearance print on December 2024 and cooperated in the investigation. He is still ready and willing to cooperate. Mr. Water submitted that he has appeared before the ILO and his statement is recorded on section 161 CRPC and thus he cooperating with ILO and accordingly he submitted that custody intervention that is necessary. Okay, your interim clearance bill dated 3/7/2024 is hereby made absolute.
Oblige, Your
Wait, please, ma'am.
Yes.
Well, I think it will take time, at least half an hour. So
it will take time.
It's already.
They have received the CD here. What happened?
41. See, is here.
41, my lord, case that we received, my lord, this matter may be taken up after some time.
You have to go through.
Yes, ma'am. Earlier rejected by your
The
lordship.
only thing, my lord, yeah, the lordship is quite aware of the facts, my lord. It's under section 13 to the
Rejected earlier, na?
very, very petty of it, this matter.
Sorry, only out to us ligata. Supplementary. Oh, state after something.
My lord.
I said it. In 49 CD is it. 50, 51 also CD there. Na? Yeah, Mr. Potakur, 49, 50,
Yes,
51.
49,
in all these, we have received
received case there.
Are there on interim earlier or not?
No.
In all these
49, my lord, I am appearing, my lord. And interim is there, my lord. In fact, my lord, I have also filed today, my lord, one additional affidavit, my lord. So may I pray, my lord, this matter will be taken up along with my affidavit, my lord.
affidavit is already got
Not, my lord, in the record, my lord. So I have filed it today, my lord. So may be taken up along with the matter, my lord. Any day, my lord.
Today, let it come, let the affidavit come.
The affidavit comes today or what you are saying?
Today they have filed, Lordship.
Today they have filed?
Yes. Lordship, it can be brought by the equation with Lordship. There is some urgency in this.
He is insisting for hearing today only or
Yes,
what?
yes, Lordship. I am
Or any
here
day,
is-
my lord, tomorrow, day after tomorrow, any day, my lord.
But you have filed already filed? You have filed
Today I have filed, my lord. Today, my lord. Sometime back, my lord.
Sometime back. May come, may not come. He's still saying it may come, may not come.
He is in interim since 19/4/23.
My lord, that is because of CD not received, my lord.
Absolutely not.
My lord, your lordship may see the orders, my lord. That is reflected in the orders, my lord. That CD not received.
Produce the orders, Lordship. I have done to the record, Lordship. We can see from the orders how many times it is taken time, Lordship. In spite of the CD being there, Lordship.
No, my lord.
Let
That
us
is,
go
in
to
fact,
the
my
record.
lord, it is incorrect statement. In fact, day before yesterday also, this is the statement of the PP. That, my lord, I am getting time, my lord, since CD is also there, my lord.
I can point out the dates, Lordship.
Yes, my lord.
8/23, 10/8/23, 12/9/23, 29/23, 27/9/23. On all occasions, Lordship, CD was available and they had taken time. It's on the record and stated.
Your lordship may see also the orders, my lord, where my lord CD is
Then
not
if
received.
the additional affidavit comes, then only we'll take the. But
then tomorrow, Lordship.
Try tomorrow.
Tomorrow.
Yes, yes, my
Tomorrow
lord. Any
then.
day, my lord.
Tomorrow.
Tomorrow, if it is you say. Tomorrow, if it is, then day after tomorrow. The list is already out. Let it be on day after tomorrow then.
Yes,
no problem.
20? April 20. Okay.
My lord, interim to continue, my lord.
In time to continue.
Deeply obliged.
But now see, with the submission made by the learned PP that you have taken time in many occasions, most probably the interim you are extended.
In fact, my
now
lord,
see on 26, obviously, the matter should be heard.
yes, my lord. In fact, your lordship will, my lord, for my lord, my consideration, my lord, there are, my lord, orders to show that, my lord, CD is not received and interim is continued. So that is for my consideration. Your lordship will, my lord, take into consideration. Deeply obliged.
Can be adjourned for a day or two, not a day. Otherwise,
Another case there is available. It's a Foxtrot matter and notice was sent. Now we have the information that notice already served. But today none has appeared. Otherwise, in case of rejection, I think we don't need to appoint any amicus curiae. But in case of allowing the petition, then Mother has to appoint amicus curiae. So this should be heard.
So before hearing, how can we say
No, yes,
text
that
not
is.
allowed?
But the materials are there.
So let us appoint the amicus the naam di dito. You are Mr.? You are Mr.?
H.S. Bora.
H.S. Bora. You are appearing for P. Hazarika?
Yes.
H.S. Bora, appearing for P. Hazarika. Submit the report. It's conflict, Mr. K.K. Bora. He has submitted and as per his instruction, the notice is also served on the respondent number vessel format. None has appeared on behalf of the respondent. In below, then up to reach the other M. Diana.
Notice served on 27/6, madam. 27.
Notice served 27/6 Mr. Sri Aruna Fukan, A-R-U-N-A-B. Aruna Fukan may be appointed as. Oh, he is here. Mr. Hazarika, you are here.
Yes, ma'am.
Anurag Fukan is hereby appointed as an ML. Otherwise, he just paid for an adjournment.
You are in late.
No,
I was in court number 18.
It's another date, such I thought that it was an adjournment.
Because it's the last item, we cannot pay for time being. That's why he's.
Okay, anyways.
Now,
that as per instruction of Mr. Parasha, that the service is already completed on this one number 2. So he was just appointing one amicus, it's Aruna Fukan. He will be intimated by the registry and it will be listed within this week, next week.
Yes, ma'am.
Otherwise, CD will be retained this CD.
Only my lord, on 30th I will be out of station.
30.
30.
30 will be out of station. 31st. Either 31st or 1st of
Yes,
August?
any date.
1st of August?
My lord.
1st of August. Registry to intimate করবে till then CDB retaining this.
My lord. Obliged.
Madam, can you take up note after some time, madam? After.
So these are the last item. After some time, I don't know. Anyway, service of notice regarding the service of notice. Yes.
Yes, I've been communicating since morning, Lordship. Sometime, Lordship.
May I please your lordship, my lord? My lord, my senior is on legs in code number 20. Can you read the matter if possible for time in lordship?
Now see, it is already. So if yesterday also Mr. Chaudhary took time for argument. So if it is maybe fixed after some time, then.
Lordship, he is on legs in code 20, lordship.
Code number 20.
20, yes.
Mr. Kyle will accommodate this sometime.
No problem.
The objection is from your side, na? And from NCP?
No, Lordship, this is custom. Gold was seized.
Gold was. My lord, here in this case, my lord, 29 gold biscuits were seized from the car which these two petitioners were driving, my lord. And they were intercepted on 4/6/2024, my lord.
2024. 24.
Now, my lord, as on today, they are 50 days behind the bar, my lord. The mandatory is 60 days, my lord. Since it's 135 of the Customs Act, my lord. And they have also quoted the relevant section and the, my lord, the year of punishment, my lord, in their written objection also, my lord, which is at page 47, my lord. Now, my lord, coming to the merits of the case, my lord. First is that, my lord, on 4/6/2024 itself, my lord, the gold was recovered from the vehicle, my lord. My lord, this petitioner's contention is that, my lord, they were only asked to bring the vehicle to Bimal Auto Agency at Jalukbadi, my lord. They were never knowing about the fact that beneath the gearbox console there are gold biscuits, my lord, which we have also mentioned in oath, my lord, and which has been corroborated by the respondent in their objection that on examination and rummaging the vehicle, the same was found. But in a different paragraph, the DRI have stated that no, it was the first petitioner who unscrewed the gearbox console and thereafter it was brought. But otherwise, other way around, my lord, the objection says that we are peddlers, my lord. I'll just take your lordship to the objection first. Thereafter, I'll make my submission, my lord. The objection, my lord, would kindly come to page 44. Initially, my lord. Page 44 of the objection, my lord. Line about 5th, my lord. Page 44, my lord. Line about 5th. During the examination and rummaging of the intercepted car, 49 gold bar biscuit from foreign origin totaling weighing so and so were recovered in the said intercepted car bearing registration number so and so, concealed the gearbox console, my lord. So, my lord, if the gearbox is working, my lord, meaning thereby the drivers would never be knowing that something is there. Had there been an obstruction in moving the gears, my lord, then at least it can be presumed that they were knowing about that. So, my lord, a secret chamber was made, my lord. Now, my second submission would be from the objection, my lord. Page 46, para 6, my lord. Page 46, my lord, it's subpara number 6, my lord. They say that under 108 of the Custom Act, they have confessed. Now, your lordship knows that section 25-26 is clear that, my lord, while I am in custody, my lord, if I make any such statement, that cannot be termed as a confessional statement, my lord. since I am there in the custody, my lord. And even the Custom Act also says that, my lord, that any confessional statement can only be taken care of during the trial, corroborating with the other materials available on record to show their culpability in the offence, commission of the offence, my lord. But other way around, if I am there in the custody, if I make any confessional statement, that would never be taken. Now thereafter, your lordship would appreciate page 48, para A. Here they say in the last two lines, lordship, page 48, they say that the first petitioner unscrewed the cover of the gearbox console. Para number A, page 48, para A.
A?
Yes.
11A.
11A.
11A, yes. Sorry, 11A. Two lines, Honor, Lordship. Then Lal Manga unscrewed the cover of the gearbox console between the two front seats and took out two abnormally heavy black color socks packages which were concealed in the gearbox console of the said car. I'll just take a lordship to page 50. Page 50. Second paragraph. Now here the DRI themselves are saying that we are peddlers. Even assuming they say that we are peddlers only. Further they reveal that I and Sri Joel, second petitioner, Lal Bin Moya, were given 1 lakh for transportation of the smuggled gold biscuits from Aizawl to Guwahati in every trip. The trip is our fourth trip carrying smuggled gold of foreign origin. Whereas in my bill application I have stated that I was never knowing about any such contraband, concealed the gearbox, I was knowing about that. This is what they have made for the first time, because in the FIR, because the DRI, FIR and the forwarding are combined. Combinedly they filed before the London CGM. So, Lordship, there they haven't said anything as reference to the statement, because these statements were taken prior to filing of the FIR. I am the, and they, thereafter they say that I am the owner of the Maruti Ignis car being registered number so and so. I brought this car as second hand at rupees 4 lakhs, but the transfer of the ownership not yet complete. The sale deed of the car is in my home. I will submit to DRI officer at later stage. But Lordship, in my bail application, I have specifically denied that the vehicle does not belong to me, belongs to one KP. I'll just show from the inventory, which is at page 29 of my bail application, Lordship. Page 29 of my bail application. Page 29, column number 7. Copy of the certificate of registration of vehicle bearing registration number MZ01S6755 issued in the name of Sri K.C. Kapninga. And above 7, Lordship would find the driving license of the first petitioner in column number 6, and in page 30, column number 14 is the driving license of the second petitioner. Now, Lordship, my first submission is that the contrabands already seized, already recovered. Since 5-6, I am behind the bars. Mandatory is 60 days. Thereafter, they never went down to the jail to take any of my statements. We are only languishing in the jail. In the objection, they have brought one more line which says that at page 49 that one Mr. Thanga came in the evening at the home of the first petitioner and handed over the contrabands which he brought on, which he carried to Guwahati. That is there in page 49. My humble submission is that, Lordship, recovered. My statements are already recovered, already taken. Nothing remains to be interrogated against me. That apart, I have already placed 2 of the medical documents wherein my daughter my daughter has been suffering from thyroid, grade 3. I'm just listing the document. And the second one is of the first petitioner's wife. She was also hospitalized. So, my lord, the other grounds which I am praying before your lordship is that the second petitioner's daughter is seriously, she had grade 3 thyroid, she needs an operation. That document, hospital documents are submitted. And secondly, my wife, the first petitioner's wife was admitted on account of hypertension and, my lord, since the husband is in jail, my lord, so she was for panic disorder, my lord. So, my lord, on medical grounds also I am seeking, and thereafter, my lord, the last prayer I will make before your lordship is that mandatory is 60 till filing of the charge sheet. If your lordship directs us to appear on each month before the IO, we are ready and willing to appear on whatever condition your lordship grants us will. We are ready and willing to abide by the condition which will be imposed by the authority. I am deeply obliged.
Immediately, lordship, the court will cease from the custody for the petitioner. Lordship, come to page 51 of my objection, Lord. Paragraph 12. 12, 13 and 14.
Five zero.
5-1, Lord. Paragraph 12. Internal page 11.
Internal page 11.
54.
Yes.
Paragraph 12. That
Paragraph?
says, paragraph 12, below.
Yes.
That Sancho have seriously compromised the economic sovereignty of the country in violation of Section 11.1 and 12.2 of the Custom Act 1962. The offence committed by them is a serious offence, as it deprives the government of legitimate revenue and undermines the country's economic policy. Well, but sir, the case is now under the premature stage of investigation, and follow-up investigation will conducted at different level and places to unveil the truth behind the crime and to bring home the truth to the other accomplices working from behind, for which remand of the accused persons to the judicial custody is required in the interest of investigation. Hence, alerting them to fail at this stage seriously jeopardize the investigation of the case, and there is every possibility of him hampering the investigation and tampering with the vital evidence. And 14. That Sancho is engaged in smuggling of high-value goods like primary gold of foreign origin and thus playing with the economy of the country, which definitely has ramifications all over India and would give a wrong message to such persons engaged in illegal activity. Then last paragraph, that Your Honor, the accused person being from outside Assam, namely Mizoram, Aizawl Mizoram, there is every likelihood of tempting the bill. This is our objection. And it is correct, Lordship, the punishment is 7 years, and as per Custom Act, and they may be detained for 60 days without filing the complaint. This is my and case diary is with me. Their statement has been recorded, they admitted everything. And whatever amendment submitted, it's compared to the record. And statement recorded under the Custom Act, there is a relevance that can be taken into consideration while trial period. And for investigation purpose, that may be taken into consideration. And what amendment submitted under section 25 of the Evidence Act, evidence are not admissible. Probably this is with respect to NDPS only, not with the customers. And this is a case diary for terrorism.
But yes, obviously you are saying that admittedly the recovery was from the person of these two people.
Yes, 2 persons from there.
These two Polish persons, but they are taking plea that they're not aware of. They were anyway, whatever. Now the question is just I want to ask you. It is already they are in custody for more 50 days.
Yes.
You are in custody
Since my lord 5-6, my lord.
Yes,
5-6-2024.
Today 50 days been completed.
But I want to ask you whether within 9-10 days, I will be able to find your
that lot of inspection I have to take.
Because this case is at the what stage of investigation at present?
Lordship, in last paragraph you have stated that because we have to find out the accomplices who are only involved behind the entire crime.
Yes.
And to recover, to know the persons who are behind them, that it is done.
Yes.
Because they were
So the other culprits are yet to be booked.
yet,
They are already
yet to be identified, Lord. Because they are stated in their statement also. And on that basis, Lordship, the IO is proceeding. Recently, Lordship, with regard to economic offence and serious offence, Supreme Court has come heavily that court should be slow in granting bail.
But
Court should be slow in granting bail.
yes. The court should be slow in granting bail, but that's because it is 7 years of offence. That's why I'm asking you. Suppose they are also saying that they are not involved or whatever. If there are some other persons may involve also in this case, their involvement is there. That I won't deny or disagree. But that is the issue.
Lordship, then let me be taken up tomorrow at 10:30. I'll obtain instruct from the IO whether he will be able to file charge sheet within 60 days or not. Because Lordship, he has not stated to that effect. Maybe taken at 10:30. Lordship, I'll obtain instruct to he is not able to file charge sheet within 60 days. Lordship, then Lordship may consider.
My lord, that statement cannot be taken because, my lord, somebody might say that I'll file, but that would prevent me from taking a bail till the charge sheet is not there. Consideration of bail is up to your lordship, my lord. If they say so, my lord, because page 40 of the bail application, only on one line on the merits, page 40 on 3-7, while my bail was rejected by the learned session judge, my lord, the learned session judge recorded that the case is in progressing stage by 3-7. By this time, already they have done everything. And even the statement that one Thanga was there, my lord, that proceeding will go. My lord would make a condition that for a month or 2 months, whichever your lordship founds, I will not leave the jurisdiction, my lord, at any condition. I am ready and willing to bear that also. If they want for this coming 7 days or coming 10 days, we need to appear each and every day before the IO will appear, my lord.
Let's come to page 40 of session judge's observation.
Yes.
Page 40 of the bill application.
Yeah.
I have also considered the submission of the learned counsel for the accused in the light of the ratio laid down by the Honorable Supreme Court in the above referred cases. Having gone through the CD, I found faults in the submission of the learned junior standing counsel of the DRI, as much as there are sufficient incriminating materials against the accused in respect of commission of alleged offence. Further, the offence is cognizable and non-bailable, and investigation of the case is in progress stage. Considering the above, respect the matter, the prayer of the accused, so rejected.
My lord, this judgment I placed before the learned session judge, my lord, wherein, my lord, the Supreme Court says that the section 135 is bailable. Only thereafter, my lord, a custom amendment was brought in, my lord, and thereafter it was made non-bailable. Yes. Up till 1 crore, my lord, within 1 crore, it is bailable till today also. Yes. After the amendment also. Yes. Only above. That is what, my lord, I am saying that, my lord, the confiscation proceeding has yet to be initiated, my lord. They cannot even file the charge sheet also, my lord. 110, my lord, 6 months period they need to grant. Thereafter, they will ask the person concerned to bring on documents. If they can legally show something, they can take back their goods, my lord. So, my lord, charge sheet cannot be filed within 60 days because there are other 110 procedure has to be followed, my lord. Because those are not there. That is why I am praying that, my lord, bail may be granted, and if lordship directs, will appear on each and every day before the IO, and whichever dates they finalize will appear there, my lord. Because, my lord, 50 days we are in there.
See, the criminal proceeding and confiscation proceeding, the two are different proceedings. Criminal is entirely different.
No, my lord. The recent Custom Act amendment says that earlier, my lord, while the inventories were seized, my lord, that were required to be placed before the CGM, the photographs would be taken, the samples would be attracted. Now, as per the new amendment act, these formalities are to be done by the Commissioner of Customs. These powers have been changed, my lord. If lordship wants, I can show everything from the act itself. Now, my lord, those proceedings have not been yet started, my lord. My lord can see the case diary also. If lordship wants, I will just show 108 for a moment. 110, my lord. For a moment, 110.
Lordship, my lord is still insisting on deciding the matter. Lordship may decide on the merit.
This is because I'll just place, my lord, 110.
My objection
close
may be
to, my lord.
considered, Lordship may pass message to you.
Provided 6 months.
Now, my lord, earlier the power was given to the learned magistrate, now it is to the commissioners, my lord. They do that, my lord. My lord, new book, my lord, page 102, my lord.
102.
102, new book, my lord. Section 110, my lord.
Yes.
It's 1D. 1D, my lord. Wherever the goods seized under subsection 1 is gold in any form as notified under subsection 1A, then the proper officer shall, instead of making an application under subsection to the magistrate, make such an application to the commissioner appeals, having jurisdiction, who shall, as soon as may be, allow the application, and thereafter the proper officer shall dispose of the goods in such manner as the central government may determine. My lord, prior to that, my lord would kindly see 1B. Just above 1D, lordship would find 1B. Where any goods, being goods specified under subsection 1A have been seized by a proper officer under subsection 1, he shall prepare an inventory of such goods containing such details relating to their description, quality, quantity, marks, numbers, country of origin, and other particulars as proper officer may consider relevant to identify of the goods in any proceeding and shall make an application to a magistrate for the purpose of. So, my lord, earlier it was there, my lord. Now they have changed. My lord, those proceedings are yet to be done, my lord. So, my lord, the charge sheet cannot come up, my lord, within 60 days. This is my humble submission. Because there are amendments, my lord. So, my lord, any conditions my lord would impose, we are ready and willing. Other way around, my lord, we are 50 days behind the pass, my lord. And mandatory is 60, my lord. And from the case diary, lordship would find that this procedure has not been yet been done, my lord. I'm deeply obliged, lordship.
Only two conditions. I learned from submit that I will not be able to file charge sheet within specified. How he can say no to this condition? Is it to the authority? And Lordship reasonably asked me to open inspection. If my landlord is not agreed to, Lordship may decide on merit. And both confiscation proceeding and criminal proceeding are two different. Supreme Court has, in one of the judgment, clearly states that both are different. Both in law. There is no bar. So how my landlord can say that we will not be able to?
My lord, I am not on that. I am only on the length of detention. And my lord, since the goods have been seized, my lord, the investigation, as reference to these two accused persons, my lord, they have done everything, my lord. They have taken the statements, my lord, goods recovered, my lord.
Report along with objection also may consider.
And there are, my lord, medical grounds also, my lord. On that, my lord, I am free, my lord.
Administrative of qualification. I also heard Mr. Istiqbal, the member of Standing Council, here, right? The objection filed by the respondent says The objection filed by the DRI is also received. CD received. It is submitted by Mr. Tiwari Blood Hospital. These two additional circumstances and they are not involved in the arrest process. It is a fact that the recovery was made from the possession of the recovery was made from the vehicle which was which are deposited conditions at the time of the interception by police, but they are not aware about the contents of the package which were carried by them to deliver it to the other place. Further, Mr. Tiwari submitted that both the petitioners have required since last 50 days, and thus the Ayog was sufficient time for their custody interrogation. Further, the Ayog did not visit the jail premises for further interrogation of the accused petitioner. You were under police remand initially?
No, madam. Not a single day.
Nor they were ever, nor the authority asked for any remand of the present accused petitioners. He further submitted that the confession made before the investigating authority also cannot be taken into consideration as consideration, and he has no evidentiary value. Mr. Tiwari further submitted that statements which were read by the investigating agency were recorded prior to filing the FIR, and for the statement of the FIR as well as statement recorded by the investigating agency also contradict to each one another. Mr. Tiwari further submitted that the vehicle, the owner of the vehicle is not the present petitioners, which is already collected. The name of the owner has already been collected by the IO, and the driving license of the present petitioner also seized by investigating agency during the time of investigation. Mr. Tiwari further submitted that the daughter of the petitioner number 2 is having a third stage of thyroid problem which needs immediate operation, and the wife of the first petitioner is also admitted in hospital due to her subsequent problem. To substantiate the same, he also furnished the medical documents. Next para. Full stop. However, these two accused petitioners are free to abide by any terms and conditions imposed if they were granted with equity. Mr. Kyle submitted in this regard that there are sufficient informative materials against the present accused petitioners, and the Learned Trial Court will also rejected their earlier bill application, considering the materials available in the case diary. Mr. Kyle submitted that in the offence committed by the present accused petitioners are serious in nature, and it deprives the government from receiving legitimate revenue and it undermines the country's economic policy also. Mr. Black submitted that the investigation is still under progress, and the other culprits involved in this case are yet to be booked in connection with this case. And accordingly, he submitted that it is not at all the case to allow the evidence to go on bail, considering only the bank condition. If further submitted that it is the admitted fact that the 49 numbers of gold bar biscuits are recovered from the car, car and cars which were under the possession of these two petitioners, and which were conceived in the safe car, and from the way they transported carried the gold biscuits, it reveals that they are also the habitual transporter of smuggled gold of foreign origin from Aizawl to Guwahati. During the submission made by the London Council for Both has also kept it valid, and it that there is sufficient progress in the investigation, but also reveals that during the time of till date or during the time of investigation, the investigating officer did not sought for any remand of the present petitioners, nor they were interrogated in the jail and inside the premises. Further, it cannot be denied that the accused petitioners are behind the bar for a considerable period of 50 days. And 50 days and that they have got sufficient opportunity to interrogate the accused petitioners, keeping them in custody. From both the IO as well as from the method in the case diary, it seems that the competition proceeding it's yet to be initiated, and in the same time, some of the other culprits involved in the case are yet to be booked in connection with this case. And considering this, I find that probability of punishing the person within the statutory period is less. So considering the length of detention already undergone by the accused petitioners, the medical ground work by the London Council for the petitioners, and other aspects of the matter, I find it difficult to address the accused on bail. And accordingly, I find that without going by the merit of the case, and considering the length of detention already undergone by the accused petitioner, I find it difficult to analyze this also. The petitioners are from which place?
Aizawl.
They are from Aizawl.
Aizawl.
2 CUT Koidibo, 1 should be from Assam. It is an pending before Asian
CGM Kamrup Metro.
CGM Kamrup. 2 CUT will be there, 1 should be an official, government officer. One should be an government officer, because their attendance, the procurement of the attendance will be otherwise difficult. You see, you try to arrange, I'm not saying that he or she should be a government employee who was under a state of Assam, but he may be a government employee from the Aizawl.
If that observation is there in the orders, if that is there in the order,
that's why I'm not saying that he should be an employee of the state government of Assam. He should be a government employee, 1 CUT. And not necessary that he should be a government employee from Assam.
Deeply open.
For the team, it should be directed to provide his correct address.
Oh, they have not. Yes, they may also furnish their
Aadhaar card.
Yes, they should condition liquidable. Other card, PAN card, if any.
They are already seized in the inventory. Aadhaar cards are there. Those are seized by the those are there, my lord. Page 29. Aadhaar seized, my lord. Page 29. The identity are already seized, my lord.
29,
my lord.
And Lordship, I'm making this commission decision about prosecution cases. The cases are pending for last more than 10 years.
Yes, I know.
Accused are not appearing.
It is very, very, very clear. Even in that, though on the basis of some period of incarceration or what these things are considered by this court or as well as by the appellate court or whatever. But if you go by the trial court, the procurement of the attendance of those accused persons are very
difficult.
Very difficult.
Now, Lordship directly to provide a GPS location to the investigating police.
Person cannot carry a GPS.
কথা মিলিব আধাৰ কাৰ্ড পেন কাৰ্ড দিব and the copy may also be obtained by the learned court below if it is already seized by the investigating officer in connection with it. If it is already seized, those copy can be used.
My column number 11, 12 speaks about Aadhaar card and PAN card. Those are seized, my lord.
That's what I'm saying. If already seized, the court may obtain from a copy of this.
From the IO, my
From IO, yes.
DPO. DPO, my lord.
In this case, my lord, charge sheet submitted.
32. And what about 22? লিখা আছে Oh, I get this. These are rejected. Now, 32. Yes, 32.
Charge sheet number received now. CS number 47/24.
CS 47/24.
Dated 13/3/24.
13/3/24. So his presumption or apprehension is first correct.
Yes.
By the time, are you on interim earlier?
Yes, Dr.
Okay, your interim will be extended for 10 days. Appear before the learned trial court below with a regular bail application.
Is under section 14 and 15 of Assam Game and Betting Act.
Yes, obviously, that's why it is the tribal by so and so that can be considered.
They would have maybe made absolute also.
No.
Then was 15 days time maybe the time.
You want 15 days? Dispose of favor 15 days. CS number of election. Says 47 of 2024, 13/3/2024. Within 15 days, you appear before the learned trial. Till then, your interim will be extended. Yes, say it. 21. Are 21? Oh, acha.
My lord, here in the instant case, my lord, the petitioner was shown arrest on 13/12/2022 and he is behind the bar for he is behind the bar for 590 days. That is 1 year, 7 months, 10 days, my lord. I have gone through the, my lord, record and my lord, subject to correction of my learned pen. Not a single witness has stated that this petitioner is involved for committing the LS offense, my lord. There is a CDR analysis, my lord. There is 3 accused persons, other 3 accused persons. Page number 34, my lord. In that, if you also go to the CDR analysis, 35, my lord. There is, my lord, not page number 35, my lord. If your lordship go, my lord, the accused person's name is, yes, name is Mohammad Ayub, Mohammad Farooq, I Amit Kumar Yaspal Singh. Not a single phone call is me, my lord, with Mohammad Ayub, Mohammad Farooq, Amit Kumar, and Yaspal Singh. This is the, my lord, facts of the case, my lord. And I want to, my lord, yesterday, my lord, my learned friend has produced one judgment, my lord.
No, just you come. Your petitioner's name is?
Omid Kumar.
You are Omid Kumar.
Yes, my lord.
Yesterday's matter also Omid Kumar.
Omid Kumar. I mentioned in both the
So
petitions.
you have to say in the call details report, your
No.
name is not there.
My name
No
is
no phone call. was-
with the accused persons. My phone call is not with the accused persons, ma'am. Secondly, please get that.
Yes.
In evidence, my lord, page 40, my lord. 41, my lord. This is the, my lord, evidence, my lord. Page 41. After completion of the certification of the properties of this case, before the
41, 41 of which page?
page 41, my lord, of my petition.
Evidence of accused.
Yes, my lord. Yes, ma'am. I am reading from my lord, evidence against the accused person.
Yes.
Yes, my lord. If your lordship go through the my lord, first, my lord, accused Mohammed Farooq is the trafficker transporter. 1 accused Farooq has disclosed voluntary statement and he is consciously involved. Accused Mohammed Farooq has also disclosed the name and mobile number, other conspirator statement. Mohammed Farooq is the, my lord, which is used the trafficking from the SDR. Mohammed Farooq, it is found that mobile number is registered so and so. From the analysis CDR mobile number, accused Mohammed is found Mohammed Farooq was in contact with Yaspal Singh, co-receiver of Ganja Vikas and co-supplier of Ganja Sanjoy 4 times and accused Mohammed at 156 times. Then from the SDR of mobile number accused Mohammed Farooq, it is found that in the name of Monideva Debroy, wife of Sapon Debroy, so and so, so and so. From the CGL mobile number of 879, so and so, so and so, Mohammed Farooq is found the accused. Mohammed Farooq is in contact with co-receiver Ganja Vikas, 1 time supplier Dev Burma. I found a bail order of Dev Burma, my lord, in other cases, my lord. He was released on bail. Subject to correction of my learned friend, my lord. As per my client instruction, this Dev Burma is same. Because, my lord, in this case, they said, we are investigating further investigation against that person who is not traceable. But he was in the jail, my lord. Sumon, subject to correction, my lord. I come later on. Muhammad Ayub is the trafficker transporter of the C1484.95 Ganja. Accused Muhammad Ayub has disclosed the voluntary statement recorded 67 and he is consciously involved 1484. Muhammad Ayub has also disclosed the name and mobile number statement. Muhammad Ayub is the driver of the truck trafficking 1484. From the SDR mobile number accused Muhammad Ayub, it is found that number so is registered in the name of Neima. From the analysis CDR, Muhammad Ayub, it was found Muhammad as a contact with Yaspal, co-receiver with Ganja, 46 times, Ganja Sanjoy, 4 times, and accused Muhammad Farooq, 156 call. These 2 persons from the possession, Ganja was recovered. And they said, receiver are someone different, that other person's name has been mentioned. Then they come, my lord, in my case, my lord, Omid Kumar. Accused Omid Kumar is the co-receiver of Ganja. Where from they got, my lord? Because I got that statement, no one has said. Accused Omid Kumar is a habitual offender. He was also involved in 179 NCB case number 19-2000, yesterday case, my lord. Accused Omid Kumar is intercepted later arrested NCB Guwahati in 19-2000 in conscious involvement and trafficking 1728 Ganja. I am involved in some other cases. Accused Omid Kumar considered voluntary section 67 NCB. He was one of the receiver 1484 Ganja. During statement, Muhammad Farooq disclosed the receiver of 100 Ganja was Omid Kumar. Where from they said, my lord? This is not available, my lord. I have shown. That's enough. They also disclosed the mobile number. So they said Omid Kumar was found to be trafficking 1728 Ganja NCB case number so recorded 19-2022. 8 so and so. Yesterday case they have stated. During investigation NCB case 18 it was found that mobile number Omid Kumar is registered in the name of Bhuvneshwar Mahato and sent the Bhuvneshwar Mahato. It was returned the different answer. Omid Kumar also told in his recorded statement mobile number so and so. Yes, man. During CDR analysis number of Amit Kumar, it was found a contact with the Ganja Dembarma. I don't know that he has released on bail. Ganja Bikas, 42, supplier Ganja so-and-so, and so-and-so receiver of the Ganja. This is their statement that I have not involvement with Ayub and so-and-so. They said I have some contact with the name mentioned Bikas and others person, my lord. They have stated, my lord. And next, owner of the truck is the Yaspal Singh. My humble submission before your lordship is that, my lord. Have your lordship? Lordship, come one paragraph 35, my lord. Page, my lord. Yes, my lord. Page 38. There, on the basis of confessional statement, NCB in 19 to the other corroborative prayer regarding Sonera submitted by the Honorable Court, pursued a record after perusal the case production warrant accused Amit Kumar NCB case number 18/2022. That I was Sonera in this way. My humble submission before your lordship is that yesterday my learned friend has put it down. That, my lord, in our High Court, your lordship kindly come one thing, my lord. That Soriful Islam judgment was passed, my lord, on 4/8/2022. That is important, my lord. That same Justice, my lord, Honorable Chief Justice Krishna Murmurari and Hima Kohli, and the person who was behind the bar for 1 year 6 months, they are releasing on bail. Before that, my lord, my learned friend has produced one judgment, my lord. Yesterday, my lord. That, my lord. Judgment কি করলে শোয়া কি হয় দিগদার পাম দিয়া রাতিপুৱা 5টা বজাত উঠি পঢ়ো এইবিলাক Mohit Agarwala judgment, my lord. Yesterday he has produced Mohit Agarwala judgment, my lord. Nowhere, my lord. Nowhere, my lord. 21 of the Constitution of India was not discussed in Mohit Agarwala case, my lord. That point is important, my lord. That is, if your lordship go to the judgment, I am not reading that judgment, my lord. 21 of, my lord, Constitution of India not at all discussed in this case. At that point in time, this point was not raised before the court. And this judgment was passed on, my lord, important date. Decided on July 19, 2022. And Soriful Islam was passed on 4/8/2022. Same judge, my lord. You also kindly go. Chief Justice Krishna Murari, Hima Kohli. Chief Justice Krishna Murari, Hima Kohli, my lord. My learned friend has said, my lord, that by producing this judgment, he has dismissed many bail applications, my lord. Yesterday, my lord, I searched, my lord. There are 60 cases, my lord, where this Mohit Agarwala has been distinguished and subsequently released on bail. Before Soriful Islam, this point has not come. A fantastic judgment has been passed by our High Court, Honorable Justice, my lord, D. Borua, my lord. May I go through that judgment? The copy is here. Court. Move to court. Yes, my lord. Yes, my lord. And it was, my lord, 1 year, 1 month, 2 days. আপুনি তো নকয় মই কৈ দিছো নামটো হ'ল খালি কোৱা নাই আজি মই বিচাৰি যাচ্ছি ৰীমা কিয়ান নেম দেখুন নহয় paragraph 12, my lord. Therefore, the scheme of Section 37 of the Act 1980 revealed that exercise of power of gun bail is not only subject to limitation concerned in Section 40 but also subject to limitation placed by Section 37 Act, which comments with a non-obstacle clause. The operative part of the said said selection is in negative form prescribed by the enlargement of the accused person, accused commission of an offence under under Act 1985, unless two conditions are satisfied. The first condition is that the prosecution be an opportunity to oppose the bail. The second, the court must be satisfied. Now your lordship come to the para 14. 13 also discussed. It is not important for this. In a recent judgment, Supreme Court of India, in the case of Narcotic Control Bureau versus Mohit Agarwala, 2022 SCC Online, SC89, the Supreme Court also taken. One thing is that Mohit Agarwala, he was custody for 1 year, 2 months. In respect of Mohit Agarwala case, the court has also taken into consideration the expression reasonable ground, referring the judgment in Amadilibia, Nodiria, Supra, and State of Kerala versus 2012 SSC. The Supreme Court observed paragraph 14 that the expression reasonable ground used clause B, subsection 1, section 37 would mean credible, possible, and ground for the which court to believe that accused person is not guilty as well. The Supreme Court observed that for arriving such conclusion, such fact circumstances must exist in a case that can pursue to believe the accused would not have committed offence to obtain for satisfaction. Is an additional consideration that the accused person is unlikely to commit offence. It was further observed by the Supreme Court in paragraph 15 of the said judgment that at the time of examining the application for bail, the context of section 37 of Act 1985, this court is not required on record to the finding that the accused person is not guilty. The court is not expected to weigh evidence for arriving finding as to whether the accused has committed offence under 19. The entire exercise is expected to undertake at this consideration of bail limited purpose him. Thus, the focus on the ability of reasonable ground for believing that the accused is not guilty of offence when such unlikely to commit under the Act. Next, your lordship come to the page 21. Para 21. Yes, that is the distinction, my lord. From a, have you lordship got it? Para 21, page to kiman Yes, have a page, my 854. 854. That from a perusal of the above quoted paragraph, it has been seen the officer invests with power under Section 53 Act of 1980 are police officer within the meaning of Section 25 Evidence Act, as a result of which confessional statement made them would be barred under provision of Section 25 of the Evidence Act, cannot taken into account in order to convict accused under the Act 1985. It was further observed that statement recorded Section 67 of the Act cannot be used as a confessional statement in the trial or offence under Act 1985. Therefore, merely on the basis of a statement made by the Lalpian Mai, the co-accused, the petitioner cannot be convicted. The observation in this court finds support from the observation Supreme Court made in Mohit Agarwala, wherein paragraph 16 of the said General Supreme Court observed that learned single judge of the cannot be faulted for holding the appellant. NCB could not have relied on the confessional statement of the respondent. And the other co-accused according Section 67 NDPX in the light of the law laid down by a 3 judges bench Tufan Singh, wherein as per majority decision of the confessional statement recorded 67 has been held to be inadmissible in the trial. And my lord, Mohit Agarwala never said that this Tufan Singh judgment is, my lord, par recuriam. Never said, my lord. At the trial of the offence NDPS, it was further observed that the admission made by the respondent custody to the effect that he had illegally traded narcotic drug keep aside. It also irrelevant that judgment Mohit Agarwala, the Supreme Court, the co-accused so-and-so interrogating officer. Now, paragraph 22, I am not, my lord, there is a, I am not make today, my lord, argument lengthy. 22 your lordship will rely upon. 23 your lordship may rely, 24. Everything is there. Then another order has been passed by this honorable court, my lord. Honorable Justice Arun Dev Chaudhary, my lord. By distinguishing Mohit, paragraph 4 he has mentioned Mohit Agarwala, my lord. And thereafter he has mentioning other judgment, he has, my lord, allowed the petitioner to go on bail, my lord. Now, I want to show your lordship one point. When, my lord, in July 2022, when Mohit Agarwala has been, my lord, produced before the court, my lord, no argument has been made, Article 21, my lord. Subsequently, my lord, there, my lord, Hussain Ara Khatun, I will give your lordship, my lord, in categorically stated that prolonged trial is not taken, my lord. Then it right under Article 21 has been violated, my lord. Your lordship, kindly come to the, my lord, para 8 and 10 of the Hussain Ara Khatun, my lord. I am not reading this paragraph, my lord. 8, 10, your lordship, kindly go to this paragraph, my lord. Because, my lord, I want to show one thing, my lord, from the Hussain Ara Khatun, my lord. Hussain Ara Khatun has discussed about the Maneka Gandhi case, my lord. A constitutional bench of our High Court has stated, my Honorable Apex Court has stated, my lord, in Maneka Gandhi cases, my lord, I am relying some paragraph. I can give your lordship this. I am only reading para 48, my lord, Maneka Gandhi. Because, my lord, whole this argument has been developed. I have gone, my lord. There is a 60 judgment Mohit Agarwala has been discussed, my lord, from the Maneka Gandhi case, my lord. This Hussain Ara Khatun, your lordship will find. No. Very Hussain Ara. 8, para 8. Your lordship, kindly go to the para 8 of the Hussain Ara Khatun. I am reading only paragraph 48, my lord. Other paragraph I have mentioned, para 9, 10, 11, 12, 24, 24, I have write down the paragraph in Maneka Gandhi, my lord, 11 paragraph. In 48, in Satomanda Swani, the court has majority that personally which occur Article 21 of the Constitution induce right to travel, no person be deprived the Passport Act by the Act. But the mere prescription, some kind of procedure cannot even meet the mandate Article 20. The procedure prescribed by law has to be fair, just and reasonable, not fanciful, oppressive or arbitrary. As my lord, yesterday I have submitted, I am not repeating. In this case also, my lord, all the document was not submitted along with the charge sheet, my lord. If your lordship go to the, my lord, document produced, and matter has been fixed for copy, my lord. Till today, not a single witness was called for or examined. In the event, charge was not framed till today. Huh? There are 12 witnesses, my lord. 1 year, 8 months has elapsed, my lord. 12 witnesses is available. Till today, charge hearing was not take place, my lord. And charge sheet was filed long. Complaint was filed 16/12/2022. Article 20 reasonable not consider in abstract hypothetical consideration like provision for full dress hearing as a courtroom trial, but in the context primarily of the purpose under is intended to achieve urgent situation. Those who are charged duty of admitting may be called dealt with. Secondly, when fullest compliance of Article 21 is required, my lord. My humble submission before I have given all the judgment, my lord. I am not reading one after another. The basic thing is that, my lord, first, I have already stated, my lord, that in Mohit Agarwala 21 point was not agitated. Subsequently, from Shafiqul Islam, it was agitated, my lord, up to Rabi Prakash and others. And when this point was argued for Article 20, your lordship, kindly see one thing, my lord. Where delay of trial took place. Moment delay of trial took place due to fault of the prosecution or of the learned trial court also. Then the petitioner is entitled for the bail. All the judgment. I am relying another judgment, my lord. One is Muhammad Muslim, my lord. I am reading para 20. So, my lord. ৰাতিপুৱা 5টা বজাত উঠি মোবাইল 9টা বজাত আহি লাৰি দিবা তোৰ কাগজ ক'ত নাই I am relying on para 20, 23, 24. Para 20 say the standard considered therefore is one where the court would look the material brought by a reasonable whether accused guilt may be proved. Thus on the court emphasis the satisfaction of express record. The accused may not be guilty on prima facie based on reasonable which does not call for the then my lord your lordship will come para 21. The appellant deserves the enlarged on bail before parting reflect which in the stringent conditions so and so so and so. And my lord, yeah, that my lord. Last line para 20 my lord. I underline that paragraph my lord. যে বাদ দিয়া আমার দুটা ওলাইতে দিছিল রাতি That grant of bail on undue delay in trial cannot be said to be a better threshold given to the which is applicable under offence and so Satyendra Kumar until having 2019 having regard to the case of opinion fact case appellate deservable. There is a further prison as a crime not only admissible so working for the above prison. In this, it's both no problem. Lordship, kindly take it, my lord. Basic thing is, my dear my lord, your lordship will look into one important matter of this case. Suppose, my lord, your lordship will visualize the situation. Suppose your lordship will reject my bail application. Suppose I am submitting. Till today, my lord, yesterday case or today case, not a single witness were examined. My lord. And there are in this case 12 witnesses, and as I think, my lord, yesterday case, there is a, my lord, 14-15 witnesses available, my lord. And my lord, not a single witness was examined. If the witness were, my lord, examined, and trial will be completed after 6 years, my lord. Basic case of this, my lord. If after 6 years, my lord, I was acquitted, then, my lord, what my right has to go? That is why, my lord, that moment, my lord, Article 21 will come, my lord. I try to satisfy, I understand your lordship, that there is a witness in both the cases, not a single witness was examined. In this case also, that case also, my lord. If your lordship has rejected my bail petition, assuming, then, my lord, there are 16, 17 witnesses, 12 or 15, some it will be subject to correction, my lord. Suppose these witnesses were, my lord, examined, they are producing the witnesses, suppose lately and other things, document is available in the NCP office, I have already submitted, it will prove from the record, if your lordship verify record with the offense report, many document is not available. If trial took place, my lord, 5-6 years, and if I were, my lord, acquitted, then where shall my right will go? That is why this law has been come, my lord, Article 21. And I have already submitted, my lord, Maneka Gandhi case. Maneka Gandhi has said that fair trial is the fundamental right of the petitioner. Fair trial, fundamental right, when come, my lord? Due to prolonged incursion. Your lordship will look one aspect of it, whether there is a prolonged incursion. Prolonged incursion means there is an undue delay in the trial. What is undue delay of the trial, my lord? They are not producing, they are not served the copy to the petitioner till today. In this case was not charge has been framed till today, my lord. And secondly, my lord, other cases, they called the witness, document was not given. My learned friend yesterday submitted that I was take adjournment. I never take adjournment in this case, my lord. I said, give me the copy. First, I have a copy. And as per yesterday, I argued in Sosikola, Natarajan and other cases, my lord, for non-furnishing the copy, violation of the fundamental right of the petitioner. That is why, That is my submission before Lordship. One bail application I got, my Lord. Suman Dev Barma was released on bail. My client said this Dev Barma is that Suman Dev Barma, subject to correction of my learned friend, my Lord. And he was in custody in other cases, my Lord. Not this case. This is case of other cases, my Lord. And they are say that we are investigating, further investigating the matter. We could not found the accused person and understand. That is my humble submission before the Lordship. And in respect of merit, I have already submitted my. Let them satisfy Mohit Agarwala are good under section 21 or not. And to that effect, my Lord, if necessary, my Lord, if found, my Lord, I have prepared a list. There are 60 cases. But for that matter, only I have taken the judgment by the Honorable Guwahati High Court. Because parity, my Lord, thing is that, my Lord, I have to submit before your Lordship is that, my Lord, that one Honorable Court Judges has considered Mohit Agarwala and allowed the petition, my Lord. And another judges, my learned friend produced that where Article 21 was not discussed Mohit Agarwala. That is my humble submission. Let them show Mohit Agarwala said Article 21.
I have not made any submission that Mohit Agarwala has discussed about Article 21. My learned friend is harping on that. You want to take from my mouth. Lordship, yesterday there was a submission from my learned friend that the judgment submitted by me were passed by 2 judges. Then I made submission that Mohit Agarwala was passed by 3 judges. Today I have brought the copy. And it was not my submission that Article 20 was. In Article 20 was considered another case. I make a synopsis I have submitted before Lordship. It's a paragraph 11, 12, 13, 14, and 16. This case mainly rests upon the article, section 37 of the NDPS Act. Initially, Delhi High Court granted bail. Then MCB approached that bail was cancelled. N.B. Ramanna, Krishna Murari, and Himata. Mohit Agarwala. Lordship, without wasting your time, I want to place another judgment passed by our High Court. Paragraph 17 to 26 are very important, and the law has been laid down. Lordship, I want to take submission that Lordship, in case of bail, there cannot be any parity. But when there need to any judgment laid down any law, then Lordship may consider. Lordship may come to paragraph 17. Animal scheme. Paragraph 17 law. This court finds courts in the submission of Learned Standing Council NCB that offences under NDPS Act are part of an organized crime wherein different roles are played by different accused persons. Therefore, recovery of or seizure cannot be held to be a sine qua non for arrest, detention of event or conviction if there are other convincing and corroborating materials. Therefore, this court is unable to accept the plea that since no recovery was made from the petitioner, his involvement cannot be ruled out. Paragraph 18. What is left now is to issue of arrest being based on statement of co-accused. At this stage, it is to be kept into mind that is only the question of grant of bail, which is the subject matter of the petition, and this court is not requiring to go into the aspect as to whether conviction on the sole testimony of co-accused is sustainable. 19. To resolve the issue, one may gainfully refer to the relevant provision of law, namely Section 133 of the Indian Evidence Act, which reads as follows. 133. Accomplice. An accomplice shall be a competent witness against a co-accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of the accomplice. Since the aforesaid aspect finds mentioned by way of illustration to come to a correct finding, that some finding the same is also required to be considered, which is extracted below. 14. Court may presume existence of certain facts. The court may presume the existence of any fact which is thing likely to have happened, regard being had to the common cause of natural event, human conduct, and public and private business in their relation to the fact of the particular case. Illustration. The court may presume D. that the accomplice is unworthy of credit unless he is corroborated in the material's particulars. 21. A conjoint reading of the aforesaid provision would lead to conclusion that though a statement of a co-accomplice can be relied upon for the purpose of conviction of a co-accused, such statement is necessarily required to be corroborated with the other relevant materials. 22. The above provision of law and the discussion made are in the context of coming to the finding of a conviction, which is much later stage. However, in the instant case, this stage has not even come, and the trial is at the very initial stage. Further, this court is of the view that if the arrest of the detention is not permissible on the basis of a statement of co-accused, no investigation would be possible, leading to a situation of anarchy and lawlessness. Further, this court is of the view that it is a settled legal position that in case of involving NDPS Act, though the length of detention may be a relevant factor, the same shall not be sole factor for determining the bail application, and various other factors are taken into consideration, like the quantity of contraband, nature of substance, nature of involvement, etc. In the present case, the contraband is commercial quantity and substance is chemically manufactured drug. Moreover, Section 37 of the NDPS Act is down that before granting bail, the relevant factors are that the court should come to a satisfaction that the petitioner is not guilty of offence, and that the petitioner has to satisfy the court that in case the bail is granted, he is not likely to commit further offence. The aforesaid two factors do not seem to be fulfilled in the present case. At this stage, it would be gainful to refer the following decision of the Honorable Supreme Court. Satpal Singh, Union of India versus Nawaz Khan. In case of Satpal Singh, Supra, the Honorable Supreme Court reiterated that the rigorous of granting bail under Section NDPS Act should be strictly followed, and conditions laid down under Section 37 of the Act are to be mandatorily followed. In that the case of Nawaz Khan, Supra, the Honorable Supreme Court has, referring to various earlier judgment, has laid down that a finding of absence of position of contraband on the persons does not necessarily absolve a it of the level of scrutiny required under Section 37(1)(b) so and so. Now, let's see the involvement of the present accused. Learned is placed. I again to place page 42 of the bail application, paragraph 55. Page 42. Uh, 42.1. The accused Amit Kumar is a co-receiver of seized 1484 kg of ganja. 2. The accused Amit Kumar is a habitual offender and he is also involved in trafficking of 1728.9 kg of ganja at NCB crime Guwahati number 19 of 2022. The accused Amit Kumar was intercepted and later arrested in NCB crime number 19 of 22 for his conscious involvement in trafficking of 1728 of kg of ganja. Next page. Accused Amit Kumar confessed in his voluntary statement recorded under Section 67 of NDPS Act in NCB Guwahati crime number so and so that he was one of the receiver of 148 so and so ganja by NCB Guwahati in crime number 18 of 2022. During the statement of accused Muhammad Farooq and Muhammad Ayub, they disclosed that one of the receiver of the seized 1484 kg of ganja was Amit Kumar. They also disclosed the mobile number of Amit Kumar, number so and so. The said Amit Kumar was also found to be involved in trafficking of 1728 of ganja seized by NCB crime number so and so. In his statement recorded under section recorded in NCB crime number 19 of 22, Amit Kumar disclosed his 8 mobile numbers, one of which is numbered so and so. During investigation in NCB crime number 18 of 2022, it was found that the mobile number so and so of the Amit Kumar is registered in the name of Bhavneshwar Mahato, son of so and so. Summon under section 67 was sent to Bhavneshwar Mahato, but it was returned by the postal department answered. Amit Kumar also told in his statement in crime number 19 of 22 that the said mobile number is not in his name and he used this mobile number for trafficking of ganja. During analysis of CDR mobile number so-and-so of Amit Kumar, it is found that he was in contact with supplier Gajan Dev Verma, co-receiver of ganja Vikas, 42 calls, supplier of the ganja Sanjay, 3 calls, then 128 calls with Sanjay, and co-receiver of the ganja Ablu, 12 calls. On the basis of his confessional statement in NCB canine number 19 of 22 and other corroborative evidence, a prayer regarding sworn arrest was submitted to the Honorable Court. The Honorable Court perused the case record, and after perusal of the case record issued production warrant of the accused so-and-so. I can't believe that. This was the materials collected. So it cannot be said that materials are not that. That he was solely arrested on the basis of his statement of co-accused. And with regard to statement of co-accused, Lordship has Animal Islam Court, Honorable Court has deliberately taken into consideration. And Lordship, with regard to delay in trial, Lordship, in Bhuvan Singh judgment, Supreme Court said that although this was not relating to NDPS case, this was relating to probably NIA, where Supreme Court in paragraph 32 that has been taken into consideration by our High Court in different judgment yesterday have submitted, that the delay in trial in case of heinous crime, it cannot be a ground for releasing the accused on bail. So under the circumstances, Lordship, no case has been made out to grant bail. Yes, Lordship, here in this case, charge has not been framed as yet. Why it is not there, Lordship, the record will speak for. And for about 5 months, learned PO was not there. And different date has been fixed. And probably last date was fixed for supplying copy to the petitioner. And on 20th of March, NCB prayed for submitting additional materials before the court. This charge has not been framed yet. Even then, Lordship, petitioner has failed to make out any case because it is a heinous crime. It's affecting the society. And this has already been, yesterday I have committed one crime, that is state of Meghalaya. In that case, Lordship, Supreme Court has already considered. And then submission of the
Hello, my humble submission before you, at this, my lord, I give thanks to my learned friend that Article 21 was not argued before the Mohit Agarwala, my lord. If your lordship determine my case, my lord, in respect of Article 21 also, I have produced many judgments. Whether the fault of the petitioner trial has been delayed. If not, every judgment is, I am not repeating, my lord. This is my humble submission before your lordship, my lord. That he has said, Mohit Agarwala never discussed about Article 20. Another thing is, important thing is that, my lord, I submit before your lordship that my learned friend has submitted something, my lord, from Amit Kumar said. It is mere statement of the NCB. Where is that CDR? Where is other? I have verified all these things. Not a single fault of the Amit Kumar to Ayub and this Yaspal Singh and Farooq Baila. Not a single phone call has gone to jail. And another important contraband was seized on 21/6/2022. Produced before the magistrate on 6/7/2022, my lord. Seized on 21/6/2022. And produced before the magistrate on 6/7/2022, my lord. In respect this, my lord, your lordship may consider, my lord. Normally what happened, my lord, a document, if any document has been seized, if any document has been produced, immediately he have to take the sample. Otherwise, my lord, there every possibility, many things should be happen, my lord. That's my humble submission before your lordship. Anyway, my lord, he has already submitted Mohit Agarwala on not Article 21. That point is most important point, my lord. Because the Honorable Justice D. Borua judgment, which I produced, my lord, everything has been distinguished on the basis of apex court judgment. That is my humble submission.
Just for clarification, with regard to delay in trial, earlier in case of NDPS, section 436, capital of CRPC was not applicable. From Satyendra Prasad until K, Honorable Supreme Court said that it is applicable in case of special case also. If we go by section 436A, half of the punishment. Here maximum punishment is 20 years. If we calculate that, then he also doesn't fall under because he is in jail only for 560 or 70 days. So not applicable in this case. And he is not arrested by films of the property. He is arrested in case criminal case where sufficient materials are placed before the court. And in my humble submission, there is no delay in trial. So Article 20 will not be kept. And in that Muhammad Muslim case, in this case, the accused was in jail for more than 7.5 years. And out of 62 witnesses, only 31 was examined. Considering that aspect of the matter, he was granted bail. And with regard to other judgments, what the Power High Court also considered, that Ravi Prakash and other orders passed by the Honorable Court, they cannot be turned as a precedent.
No, my lord, humble submission is different, my lord. I am not said on 456A, my lord. That moment is, my lord, Article 21, your lordship knows very well. Article 21, there accused has a right for fair procedure of trial. There is a judgment for non-producing violation of Article 21, as well as, my lord, I am not that. In that duration of period, what has been done by the NCB and the court, if delay has been took place due to the fault of the accused, then different aspect of the matter. 1 year, 7 months, till today document was not served to the petitioner. This case, my lord. So,
in this case also.
My lord.
And in this case also, you have not furnished with the document.
Yes, my lord. Some one my lord, complaint offense report has been given. The other document are not given, my lord. That is why matter has been fixed for copy, my lord. That is violation article. What happened, my lord? I am one thing, my lord. You have seen there is a judgment of Aslam Zahir, my lord. In NSA case, my lord. What happened? There is a 7 days delay of disposing the representation. In that judgment, 1997, I forgot 3 SSC or something, my lord. It's 3-5 or something. Today, my lord. That said, if a 7 days delay is not important, if delay took place due to the, my lord, authority, my lord, then fundamental right under Article 21 has been violated. That has been discussed in other judgment also, my lord. Delay 1 day, 2 day, different. In that case, 7 days, my lord. Here, 1 year, 7 months. They have reasonable explanation. If they given, my lord, I am out from the case, my lord. If they are not given reasonable explanation, my right under Article 21 has been violated. And my lord, Sosikala has categorically said, document not given document is violation of Article 21 of the Constitution of India, my lord. Yesterday, I am not repeating, my lord. By the way, my lord, I am sorry, my lord, my voice has been loud, my lord. Sometimes.
The record is already there. Much. And I have submitted on the
and Muhammad Muslim has been declared Honorable Justice Arun Dev Sudhi, Honorable Justice Devashish Boromal. Both judgments.
Against them, there are many judgments.
Both ways.
Yes, sir. I have submitted 4 out of them. Much obliged.
Take the whole day writing of the that time we submitted, it will take 20 is there. 20 is there. Is a bill measure. here, what matter 50 left, 51. If it takes time, 41, then we can call for 51 plus 40. These are paid hearing. Only 51 left. 51. It is individual. Anyway, it is AB.
Great, Your Lordship. 438 application, Lordship. FIR, Your Lordship will find page 11. Lordship, here regarding service of notice, Lordship, I had a state with the IO, Lordship. Unofficially, Lordship, though he has not given me any written instruction, Lordship, unofficially he has told me that he tried many times to serve it to the informant's family, Lordship, but they are refusing to accept notice.
Refusing to accept.
No,
Is this is instruction from the IO?
IO, verbal instruction, Lordship, though I am yet to receive the written instruction, Lordship. So, Lordship, can I pray that the amicus curiae can be appointed on behalf of the informant?
No, see, refusal is a different thing.
Refusal, Lordship, what he has stated me, Lordship, that the informant probably are under the impression that if they accept the notice, then bail will be
granted.
That is the impression.
But how can we say that about the impression? Refusal is other thing, and suppose accepted, not appeared, then we may appoint an amicus to represent.
Yes.
Somehow there may be any reason for their non-appearance. But if they already refuse, that is other.
That's the difficult.
To have because refusal is a very detailed thing.
No.
So in that case, why don't you ask IO to give a written?
Yes. That I can do. I have already told him, Lordship. He has assured me that he will be giving me one written instruction, though I have not received it yet, Lordship.
Not yet,
Not yet, Lordship. So let it be taken up as the last item, Lordship. We will try, Lordship. I will just communicate once again, Lordship.
Will it be okay, Ahmed?
Or your Lordship will fix it tomorrow at 2, Lord. That will be good because this
problem is
continuously coming
supplementary
up.
is already out and the list is already out.
In supplementary, it will be listed at 2 only for because of their part, Lord. Because this matter is pending since long, and because of that service, his bail application is not considered. Only there. And even if your Lordship see the FIR, not the victim girl initially lost the FIR, not the person to whom she informed. The third person lost the FIR. So those things are there. Today I am not saying only tomorrow at 2, Lord.
Kim, can it be possible tomorrow at 2? At 2 may not be possible. Already fixed matters are there for most probably again tomorrow 2, 3 numbers. 51, 52 matters are already been there. So at 2 tomorrow may not be possible. Day after tomorrow we do Friday. We can fix it day after tomorrow then. Tomorrow may not be possible. Because this NDPS and the special act cases that we are dealing with, those takes some time in fact for hearing and all. So let it be by day after tomorrow. Take instruction, only that instruction. If it is there, then obviously if it is the rejection is there, then no need of appointing an amicus if a refusal or rejection. But if acceptance is there, then the matter will be different. 26. Realistically.
At 2. Public.
May it please, Your Lordship. Lordship called for study. Is there any updated sort of thing?
Is there received money? Earlier rejected by your Muslim game and betting act money?
Yes. Yes, it was earlier rejected.
Earlier police apprehended 2 persons at the spot. Some of the tickets also recovered from those accused persons, and the present accused person may not fled away from the spot. And now police is searching the same report. Now
Not
still
fled away, my lord. This is not the correct verbatim. Not fled away. He was not there at all. And later his house was also searched, nothing recovered. Only the 2% apprehended, they named this particular fellow. And the reason for filing this application second time, my lord, paragraph 14 is very important. And thereafter I'll come within the ambit of, my lord, paragraph 14 of the petition, my lord.
Considering earlier in some cases the law has now at this stage we granted some of the persons bail regarding let him, because at this point of time the accused person fled away from the spot. That is the record of this case diary. Let him appear and record the statement, and thereafter I will get the updated case diary.
No issue.
That can be done.
Yes.
That
My
will
lord,
be better.
my lord, before that, my lord,
Because what I'm saying, in the earlier order, it was seen from the materials available in the case diary. As per your submission, he was not fled away, he was not fled. But from the materials available in the case diary, it is said that he fled away from the place of occurrence.
Yes.
So same, if Mr. Botakur has submitted that same thing will come here. So better we can do one thing. Let your petitioner be an interim so that he can appear and his statement may be recorded. Thereafter we'll call for the
absolutely, absolutely. Even if your lordship wants to let the matter be pending, he appears. If anything wrong goes, my lord, I have absolutely no option. He can be taken into custody. No. But irrespective of all those sort of things, my lord, why I file? Because there is some very pertinent issue. Because his mother and wife, seriously. And more importantly, he is the lone fellow. He is a Pancho Pona mother. Lone fellow. So,
it is submitted by Mr. Botakur that the earlier bail petition was rejected after perusal of the case diary, and he repeats the same materials in the case diary. Accordingly, he submitted that one chance may be given to the bail petitioner to appear before the IRF and cooperate with the investigation. Mr. Chakraborty submitted in this regard that the second Pardon? Oh, sorry, what I said. Submitted that your medical ground is there.
And that apart, my lord, just little concession, my lord. That apart, for the latest Supreme Court judgment, my lord, very pertinent, my lord, this particular. Since your lordship has agreed, my lord, I'm not going into this detail, my lord. Also, specifically asserted that in such a sort of offences, my lord, there shall not be any sort of automatic arrest. There has to be section 41A, my lord, has to be taken care of. What is that?
You have not received the 41?
No, my lord, nothing.
In this case, there is no question of my lord issuing any 41 notice, because police, my lord, apprehended those accused persons from the spot. And thereafter, my lord, as per the record to be, he fled away from the spot, my lord. There is no scope for
one very important issue, my lord. Very, very sarcastically, my lord, when I went into the research since 1977, there was no conviction. Our High Court has set aside many order passed by the court below, my lord, giving conviction in such a matter. If your lordship appreciate, but I'm not going on that. Already done this.
So you want to say that we should encourage those?
No, absolutely not, my lord. There is
because they are all set aside.
Let him appear, my lord, already interim granted, your lord.
My lord, the problem is because of prosecution, my lord, and the act itself. I can show lordship. But anyway, lordship, I'm not on that.
Considering the submission, I find it fitness to extend the privilege of interim so and so forth. After that case diary call for freedom. After that case diary we call for freedom. And CDP return account. It will be a You will be under interpretation, appear before the IOT within 7 days from the date of order.
My lord.
Cooperate him in the investigation.
Absolutely. Any condition.
On my lord, 29/8, my lord.
29.
29.
Will I liquidate it? Short query.
29. 8.
We are fixing it on 29.
My lord. Deeply obliged, Your Lord.
My lord, this matter pertains to Zimma of Battle Nuts matter. In this case, my lord, what happened?
Zimma of Battle Nuts?
Yes, Battle Nuts. My lord, the Battle Nuts loaded with a vehicle, my lord, had collided. Battle Nuts, my lord, loaded with the vehicle is collided with another vehicle, for which, my lord, the police reached the spot and seized the vehicle and the Battle Nuts. There is no complaint filed by anybody. There is nothing. Police registered a case, my lord, and seized the Battle Nuts. I, being the owner of the Battle Nuts, my lord, filed a Zimma petition before the learned CJM. Learned CJM, my lord, issued notice, police appeared, filed compliance report, and also the learned magistrate perused the agriculture report. On perusal everything, on hearing the prosecution, learned CJM granted Zimma of the Battle Nuts to me. You? Yes. However, my lord, on getting the Zimma order, I appeared before police. Police had not handed over the Zimma. Subsequently, my lord, police taking time, the prosecution taking time before the CJM, that they will file a revision before the learned session. Accordingly, my lord, in this way, they passed 1 month. Thereafter, they filed a session, my lord. And against this, my lord, sessions proceeding, I before your lordship, my lord. And so, my lord, kindly see the order passed by the learned CJM granting Zimma, my lord, 2/4/2024, page 32. Page 32, my lord. This is the type copy of page 34. This is the Zimma order. Perused record and report regarding seized Battle Nuts. Considering charge against the petitioner accused, I found keeping of seized Battle Nuts until disposal of the case may cause loss to the petitioner, being the seized nuts are perishable in nature. So petitioner is allowed to take in Zimma of seized Battle Nuts after furnishing bond equal to amount of seized Battle Nuts, inform accordingly. Thereafter, my lord, page 35, the police, on the strength of the notice, I have honored to report you that with a sense of overwhelming the sorrow of deep regrets, I beg to lay before your kind self and actual truth that on 4/4/23, that is, in this case, my lord, I have not denied the Zimma order, but police, despite the Zimma order, police has not given the Zimma. So, police was shock-caused. Accordingly, police given this reply, my lord, page 35. That, sir, I have not denied the Zimma order of the seized Battle Nuts to the petitioner. Neither did I send him back from the PS. On that day, the petitioner did not produce any identity proof, and later he went from the PS on his own, and till date he has not appeared before me at the PS for Zimma of the seized Battle Nuts. That's I have to say. Thereafter, my lord, page 36. This is also submitted by the police that on the strength of your kind order, I have the honor to report before you that I have filed a revision petition before the Honorable Court of Session Judge Karimganj requested for appeal to modify the order of Honorable Court of Chief Judicial Magistrate Karimganj dated by letter number so-and-so to Superintendent of Police Karimganj, but till now no any comply has been received from the Court of Session Judge Karimganj, so we are not able to release the seized Battle Nuts to the petitioner. In this case, it is, my lord, dated 22/4/2024. But this is a totally false statement. On that date, my lord, no revision was filed. The revision was filed, my lord, my lord, page 51. For 7/5/2024. On that date, revision was filed. Although, my lord, on 22/4/2024, police filed a report before the learned CGM that revision has filed. So police filed my lord false statement, and in this regard, pursuant to the dishonorable court's order, my lord, page 55, my lord. I'm not taking much time, my lord. Page 55. There is order of dishonorable court. In this regard, honorable court, my lord, opined that page 60, my lord, the operative portion. Coming to the point of quality of the reckoners, it is the specific stand of the petitioner that the same was sent for this industrial use. The FIR on the basis of which the reckoners were seized nowhere reflects that the reckoners seized are not in the human consumable. Rather, it is their case that the veterinary supari was the Burma origin and booked by unknown person from Dimapur railway station with false and manipulated record. Surveying the real motives, if the materials so seized are suspected to be foreign origin, the police will have no jurisdiction to prosecute the confiscate such products under the provision of IPC. Rather, it is the authority under the Custom Act who are having power and authority to seize the same and confiscate the same under the provision of Section 115 of the Customs Act 1962. In as much as the Honorable Division Bench in so-and-so laid down, the police shall have no authority to confiscate and prosecute when the seized materials are alleged to have been foreign origin. The court so-and-so, let it while dealing with the issue whether a confiscation of seized goods by custom can be ordered when it was found that it is not human consumable. The court answered that if the confiscated good is not human consumable, the same should not be concern of the custom authority inasmuch as the seized goods are used for human consumption, even though not consumable by human, shall give rise to fresh cause of action to take action against those erring persons under appropriate provisions of law. Therefore, this court is also of the view that applying the same principle, the learned magistrate ought not to have been rejected such pair of zimma. In view of the aforesaid reason, this court is of the view that the seized reckoners be released to the petitioner with the following condition. So, my lord, our Honorable High Court in various judgments are saying that in this regard, the zimma should be granted.
It's already a context other.
The other, my lord, not in other judgment, my lord, in another case, our Honorable Court granted zimma. Here in this case, I am the owner, my lord. Challan in everything I have given. All documents I have. I am the absolute owner. And
how come to why your revision petition was allowed in your petition?
My lord.
Your revision order is have an
No, my lord. I have filed CGM granted zimma, my lord. Prosecution filed
page 54. Page 54.
Come to that one.
Page 54, my lord.
54 is under challenge.
Yeah, this is under challenge.
Where is the final order?
There is no final order, my lord. I have challenged this proceeding, my lord. Because, my lord.
Now, my lord, already date is fixed for my lord LCR and my lord hearing, and now he approached before this honorable court by way of this filing.
It is, my lord, on the first day, my lord, it is stayed by this honorable court, my lord.
He needs
that
to
proceeding is
that,
stayed.
yes, my lord.
That means it's under pending.
Yes,
pending.
Still pending. My lord.
Pending, my lord, stayed, my lord. Stayed.
Your CGM order is stayed.
No, my lord. A CGM order is stayed by the session judge. A session judge order, that order 9/5/2024 is stayed by this honorable court, my lord, on order dated 27/5/2024. In an interim measure, my lord. Proceeding is stayed, my lord.
Ultimately, my
advice. What is supari should come there.
Yes, my lord.
CGM passed the order releasing supari.
Yes, my lord.
Division bench stayed that order. This court again state the order of then what
Not state the order, madam. State the proceeding, madam. State the proceeding before the learned session.
Yes, state proceeding and before stay.
Yes, madam. So, madam, I am seeking, my lord.
If this order is stayed, the proceeding is stayed.
Yes. I am seeking, my lord, the order from this honorable court to direct the CGM to direct the police to grant to hand over the zimma of the veterinary pursuant to the CGM's order.
Well, how that order can be? And your lordship, the present position, he is making lots of allegations against police. Now, well, the present position is that that CJM court's order has been stayed by the session court. While challenging that order, my lord, regarding that High Court order, my lord, I have not gone for it. But the present position is that everything has been stayed. So now LCR and CD and LCR was called for. I have received the LCR and CD receipt. I have gone through the records. I have also flag marked in the case diary and my lord, LCR details about the case. And during investigation, my lord, what happened? He totally failed to, my lord, prove the ownership of those betel nuts. My lord, initially he stated that, my lord, he, my lord, purchased these betel nuts from someone, Omid Bosak of Borpeta, and thereafter carried it to, my lord, Karimganj. Later on, while during investigation, police, there are 5 toll gates from Borpeta to, my lord, Karimganj in both ways, through Haflong and through, my lord, Meghalaya. In no toll gates, my lord, police, my lord, in this case, my lord, there is everything in the police, my lord, thoroughly investigated the entire matter. There is no such receipt of any toll gates that, my lord, on that particular, my lord, while transporting those betel nuts, he paid. There is no such receipt. And, my lord, most interestingly, in this case, one Babul Hussain, who was the driver of the vehicle, my lord, because initially in this case, my lord, one accident occurred, and due to that accident, ultimately police seized all these, my lord, betel nuts, and driver one Babul Hussain died on the spot. And he stated that, my lord, that driver, my lord, he has to, my lord, transporting those vehicles from Borpeta to Karimganj. Police, my lord, while, my lord, on CDR analysis, police, my lord, found that, my lord, Babul Hussain's mobile number is at Mizoram in a particular place and only before the date of the incident, my lord. So he is lying before the police that he is the owner of the, my lord, those betel nuts. Those, my lord, betel nuts not, no, that is, well, very clear from the records of the, my lord, LCR city, my lord, that those betel nuts were not transporting from Borpeta to my lord, Karimganj through any of the routes, through Haflong or through, my lord, Meghalaya. And in fact, the driver who was, my lord, died on the spot on that day, he was actually, his mobile number was there. CDR report is also available in the case diary. He was at Mizoram before the day of the incident, my lord. So he is lying before the police, and he said that he purchased it from one Omid Bosak of Borpeta. He failed to produce any records, and, my lord, in fact, police, my lord, inquired by contacting Omid Bosak. Then he told that I have not, my lord, sold any such Erica nuts to the present petitioner, my lord. So, my lord, he totally failed to prove his ownership before the trial court. And thereafter, my lord, although, my lord, Planet CJM granted Zimma in his favor, and because of these reasons, my lord, the state has challenged before the session court, and ultimately Planet session court has stayed the order. So, while matter is pending before the session court, you will have to prove.
The matter is still pending, and it is
Yes,
before
my
the Learned session judge.
Yes, my lord.
So, pass the order.
Yes, my lord. So at this stage, my lord, this criminal petition is not at all maintainable, my lord. My prayer before your lordship, late session court may decide regarding it, because now this honorable court, how can this honorable court will verify all these documents and decide ownership of the, my lord, betel nut? That only trial court will decide. By if now also you do have some documents, then again you can produce before all these documents before the trial court.
That fact was
So
decided.
what prevented you to produce all these documents before the
Prove your case
Learned
before the
session
session court.
That fact,
No, not Learned before Learned revisional.
Learned,
Because now against the order of CGM, they approached the judge for the revision. So in revision, you will get ample opportunity. Contest the case to place your documents, to place the evidence which are in your favor regarding the documents, regarding the booking of those Erekanars, taking the everything. So now, because without doing anything now, session court has simply passed the order and was all for the case. And obviously, operation has to be stayed, because
Yes,
otherwise,
sir.
if the catalans are released in your favor, then there will the entire revision petition become infraction. So in that case, the order was to
my lord, in this regard, my lord,
My prayer
suppose
before.
any order was passed by the revisional court against you, suppose, or favor, whatever, that is, there will be a scope for
my lord, these are raw materials, my lord. Keeping this in custody.
so why you are delaying
Because he is delaying the
you
matter,
are
my lord.
delaying now.
My lord, for my lord, for early disposal, for early, my lord, the relief, my lord, I approached before this honorable court.
You want
Pursuant
to, if you want to direct it to the
Yes,
immigration judge for early disposal.
No, I think the my lord, pursuant to these orders, my lord, various orders passed by this honorable court, and also
These
the
various orders came later on because your matter is still, pending. It's not yet decided. Against you or against in your favor, this matter is not yet decided. So it is very
my lord, then I would
still
like to
come before the approach.
I would like to adjourn this matter to take some other judgments in this regard today, my lord.
Again, he wants to delay the matter.
No,
Matter, my lord, your lordship, yes.
Whether, my lord, in the same way, whether any judgment is there, my lord, I would like to pursue, my lord.
Now see, matter is very simple. You have placed one judgment also of this our court. That matter is different thing. Your protection was over there, the order of confiscation was not there, the regarding the consumption of the whether the human consumption probability, these things are discussed independently, judgment passed by this court. Yes, obviously this thing should taken into consideration. But the question is that at present case pending before the session just only for disposal.
In the same footing, my lord, the other our coordinators passed this order in the same footing also, my lord.
Well, ultimately, my lord, there is possibility that session court may pass order in his favor also. My lord.
Obviously, if he produces all the documents which are in favor regarding the booking of the Arakanas, the ownership of the Arakanas, everything.
Yes,
until now, most probably there is no such kind of report because that these are not fit for human consumption and all. So in that case, we get the demand.
And he can produce all these documents.
Operating the revision report because CGM order, if you go by the order of CGM, it's a very thick kind of order. There is no such discussion in regards to that. In regards to your ownership, everything, there's no discussion. So most probably they may be agreed for the order, but that revision is a day approach the revision because during the some sort of things have come out the supposed to be investigation for the knowledge of the that the matter by what we thought the matter
My lord, at present stage, my lord, to take some instruction today may be adjourned, my lord. Explanation from the client.
Because what I'm saying, your case is very particular, very clear. So rather, this clear your view. Now you have filed this revision well.
Endeavor shall be made by the learned session court for early disposal.
This is filed on 24 May, 24/5/2024. So, my lord, I would like to take some instruction from my client whether that can be done or not.
Because all these relevant documents were submitted for us, or it was submitting that he is the actual owner of the case. Effective at the time of hearing, he can produce all these documents because Mr. Waterford actually submitted is not proper for us to assess the ownership of the those So we are adjourning it today. When it can be will be available, over will be convenient for you to.
Your lordship, please. Maybe children.
Like it's been a first week of August because there are lots of shortage of 5, 6 August. 7. We are listing it on 7.
Obliged.
Yes.
इधर जिम्मा अब मोबाइल ना ओके
For saving here for other
My lord, my senior is in court number 24. Kindly pass over the matter.
Pass of the matter for the today or for
today.
Otherwise, my lord, matter is regarding Jimma mobile phone. That not. My lord, I have the report. My lord, as per the earlier order, my lord, there is the direction to bring a report. My lord. So mobile is given to FSL.
there is not. Your senior is Mr. Airtik. It will be listed after one.
After one is
yes, sir.
Map is your lordship. There is a 482 application lordship. The posting of NI proceeding lordship. So I submit lordship and see the order dated 27/2/2024.
Here, Mr. Khan is appearing for the respondent.
Two.
So number two.
Two.
The case of washing.
Washing lordship. Washing of NI proceeding lordship. Only see the order dated 27/2/2024. In this on our submission already recorded lordship. 27/2/2024.
Order.
Order.
Order of this court.
This court, Lord. It will be clear for this convenience for this court, Lord.
Yes, there.
In this case, Lordship, yes, subject. In this case, Lordship, the present petitioner, Lordship, has taken loan from the respondent number 2 father an amount of rupees to 3 lakh, Lordship. In this regard, and one fine note was when we was taken loan, Lordship, one fine note was made, Lordship. That is, I have annexed in page number, Lordship. Page number 21, Lordship. Page
number
21, Lordship. Kindly. The top, Lordship, hand note, the written hand note, Lordship, top. Now, Boraba, Lordship, Nebbasali. Nebbasali is the father of the respondent number 2 in this case. And when it was written, Lordship, they cross because they cannot use that any other proceeding. That's why cross mark. And Barabar is an Abbas Ali. Abbas Ali is the father of the respondent number 2 and complainant of the NI proceeding, father of the complainant of the NI proceeding. Lordship. Peter Soinso, Gao, Hatipara, Post Office, Hata, Moza, the ring data, and that is made on 26/2/2022. And Likhita Hanal, this is a presentation. Hanan Ali Khan, Pitas Sofiruddin, Gao, Mohimari, Moza, Koremari, Thana, Soiga, Gombo, in data. Fotopotra Mide Kazong, more Tokar, Bikek, Dorkar, Huat, Ukta, Baravazana, Horbo, Mood, 3 lakh, Toka, Rin Lolo. Jiman Din Loke, 8 Toka, Gradibo, Noarim, Himan Din Loke, Sari Toka, Koi, Hood, Adai di Takim. Pakak Take, whose who স্বাস্থ্য শৰীৰে সু জ্ঞানে হেনত উল্লেখ থকা নগদ হাতে হাতে বুজি পাই এই দলিল লিখাই দি সই কৰিলোঁ অন্যথা বৰাবৰজনে মোৰ ওপৰত আইনী ব্যৱস্থা ল'ব পাৰিব আৰু উল্লেখ থাকে যে উক্ত চেকৰ জৰিয়তে কোনো লেনদেন কৰিব নোৱাৰে দিছ ইজ চেক লৰশ্বিপ উক্ত চেক মিন্স কাইণ্ডলি সি দ্য পাৰ্টিকুলাৰ লেফ্ট সাইড লৰশ্বিপ নোট লৰশ্বিপ দায়বদ্ধ in left side and the left side দায়বদ্ধ হিচাপে এস বাই গুমি হাকাৰ এখন 745835 নম্বৰ উকা চেক দি টকা লোৱা হয় আৰু টকা ঘূৰাই দিয়াৰ দিনা উক্ত চেকখন ঘূৰাই দিব লাগিব and this cannot is made in presence of one witness two witness that is Vikas Das and Ziarul Haq and Likhok Lordship Amirul Haq Amirul Haq. That is on 26. Thereafter, what happened in this case?
So, how you are related with Imran Hussain?
Imran Hussain is the son of the Nebbas Ali. Imran Hussain's son is the Nebbas Ali. Through the son of the Nebbas Ali, Imran is the son of the Nebbas. Through the son of Nebbas Ali, that is the Imran Hussain. The said check present in the bank lordship by entering illegally 10 lakh rupees, and which was and actually he was taken loan to 3 lakh, but for his son he was present, and when thereafter the petitioner returned the said amount on 27/8/2022 to the petition, and on that date the petition that Nebbas Ali, the father of the Imran, returned the said hand note and postmarked it and said that but not return the said blank check, and said that the check was lost somewhere. If I get, I will return it. Thereafter they are not delivered. Thereafter the petition the respondent number 2 sent a legal notice to the petitioner. Then he came to know that the said check is present illegally missed. Thereafter immediately he contact with the father of the Imran, and father of the Imran assured him that we discuss the matter amicably and he will wait sometime. Actually he wait sometimes, and but thereafter they are not response, and accordingly the present petitioner discussed with the advocate, his English advocate, and his advocate advised him to reply the legal notice, and thereafter he replied the legal notice. I have annexed reply the legal notice, and he also lodged a FIR against them. That is page 29. Kindly send page 29. That married lordship. Rajaharkari Hannan Ali, this is the present petitioner, and Podokia Nebbas Ali, this is another, from where he was taken loan and blank check was issued. And Imran Hussain, this is the son of the Nebbas Ali, and complainant in this NI proceeding. Hanmanpur Vinati was the 26/2/2022 তাৰিখে সাংসাৰিক কাৰণ টকাৰ আৱশ্যক হোৱাত উক্ত 1 নং পদকৰ পৰা মুঠ 3 লাখ টকা ঋণ লৈছিলোঁ। লগতে দায়বদ্ধ হিচাপে মই SBI গুমি শাখাৰ এখন 745835 নং উকা চেক উক্ত 1 নং পদকক দিয়া হৈছিল, আৰু উক্ত ঋণ লোৱা টকা ঘূৰাই দিয়াৰ দিনা দলিল আৰু চেকখন দিয়াৰ কথা হেণ্ডনোটত উল্লেখ কৰা আছিল। মই ইতিমধ্যে যোৱা 27/8/2022 তাৰিখে উক্ত পদকৰ সম্পূৰ্ণ টকা ঘূৰাই দিওঁ, আৰু এই টকাৰে 1 নং পদকৰ পত্নী নামত আমিৰুল হক নামৰ ব্যক্তিজনৰ পৰা জমি খৰিদাৰ সূত্ৰে বায়না কৰে, আৰু এই টকা উক্ত আমিৰুল হকক মই প্ৰদান কৰোঁ, আৰু উক্ত দিনা হেণ্ডনোট দলিল ঘূৰাই দিয়ে যদিও চেক যদি 745835 নং উকা চেকখন বিচাৰি নাপায় হেৰুৱা বুলি ঘূৰাই দিয়া নাছিলে। বৰ্তমান 1 নং পদকে ঘূৰাই নিদিয়া উক্ত উকা চেকখন 2 নং পদকে নিজৰ ল'ৰাৰ দ্বাৰা 10 লাখ টকা বিচাৰি মোক ব্লেকমেইলিং কৰি আছে, লগতে মিছা গোচৰ আদি দি উদ্দেশ্যে ষড়যন্ত্ৰ কৰিছে। Accordingly, the case was registered as Goramari PS 89/2020. Thereafter, after investigation, the Goramari PS already submitted charge sheet against them. I have this is the charge sheet against the and after investigation, sufficient material found in the charge sheet. This is the charge sheet against them file. This is the PRC case number. After charge sheet, the case is PRC number, lordship. And if you see the charge sheet number 40 and police station Goramari, lordship, and past number 89, there is a Goramari business on that. And if you see the table, lordship, and column 1, name and address of the complainant Hannan Ali, and if you see the table in column 3, 4. That is name address of the accused Nebbas Ali, son of Kamal Sheikh, second Imran Hussain, son of Nebbas Ali. And if you see the column number 6, lordship, there is a witness who at the time of investigation they record the statement, lordship. Hannan Ali, first witness, second Ziarul Vikas Das. There is Vikas Das in presence where the hand note was made. And in this case also, because there's also witnesses, lordship. And Ziarul Haq, lordship. And Amirul Haq, for is Amirul Haq. Ziarul Haq also in witness in a head note, Lordship. And Amirul Haq also Likhok. He was the writer in a head note. He is the witness in this case. In the now the charge column 7 here. Married. অভিযোগ পত্র সমূহ বিবরণ এই যে যোৱা ইন 16/9/2023 তারিখে
It's okay. Party didn't try.
Yes, Lordship. Now, Lordship, if you, in their complaint petition, if you see the complaint petition, they claim that the petitioners give the respondent number to give a amount of rupees 10 lakh. But in his claim petition, there is no anywhere mentioned that this is the document I have given him the 10 lakh document. There is no any document, and there is no any mode of transaction, whether it is cash payment, whether it is bank transaction, whether it is. If you kindly see the complaint petition, Lordship. That is in. I have also made a complaint petition. That is page 13, Lordship. In my petition also I have an next complaint. Para 2, Lordship. The accused person borrowed and took an amount of 10 lakhs only from the complaint on 8/1/21. There is mentioned 8/1/21 he borrowed took. An accused person took the efforts and with a promise to send to the complaint on demand. On good faith, the complaint gave the said amount without any. The complainant give the said amount is a huge amount, 10 lakh rupees, without any documents, whether it was cash payment, whether it is bank transaction. There is nothing mentioned in the. Thereafter, after 2 years, Lordship, he demand, and accordingly that he demand that is the para 3, Lordship. When the complaint demand the payment of said amount due to him from the accused persons on 5/8/23. After 2 years, Lordship, issue a check rupees 10 lakhs. What check? There is not mentioned. Issue a check, Lordship. Issue a check only discharge of his loan amount due from the complaint, and on the complaint on good faith take the said. There is no any major hot check, whose branch checks, there is no whose branch checks, what is the name of the bank, there is nothing, Lordship. Now the complainant lodged demand complaint that he has lost issued the check. But the present petition never issued any check to the petitioner. If you call the record of the PRC case number, the Gorameri case number, there is a clearly get the clear vision that the statement of the hand note witness and the succeeded witness, there is clear the 161 recorded there are statement also. That may be clear whether the check issued Imran or Abbas Ali. Till my humble prayer, this kindly call the PRC case number to record of the PRC case along with the CD, Lordship, and tell that further proceeding may kindly be stay at this stage, Lordship. No, Lordship, there is no any stay. The first order, the stay will be considered at the time of receiver LCR, Lordship. Case record.
In this case, Your Lordship.
Gorameri 89/24 was already called for it.
That is but it is not received because in the meantime the charge sheet submitted, Lordship. This is the Gorameri case to charge sheet, Lordship. The case number, the case that was called, that subsequently the charge sheet submitted. Maybe if they reply the.
Lordship, in this case, Your Lordship, I am referring for respondent number 2. Here in my friend, page 21, one hand note, he has referred this, but this is the handmade, Your Lordship. In here, nowhere, there is no any signature of the complainant. I mean the respondent number 2. It is their own document, they have prepared it, and by this they cannot say that this document was executed by the respondent number 2.
Now, Your Lordship,
Your
NI Act.
Your signature is not.
No.
May I clear, Lordship? This is the hand note. This is not an agreement. This is hand note. I give a assurance that if I am not return that money, that you can proceed a legal action against me. His signature is not legal.
It is a hand note.
Lordship.
Your signature
Their
must not be
signature
there.
may not be necessary, Lordship, because I am giving the assurance, Lordship.
Then what is the authenticity or genuineness of the document?
If
Signature is not available.
Lordship, whether it
Suppose
is
signature is not available, what will be the genuineness of this document?
that is the witness, Lordship. They said, Lordship. The witness in the hand note, Lordship, and succeeded witness, same witness, Lordship. If you call the PRC case number case diary, then it will be clear, Lordship, whether the hand note made in presence of there or not. It will be clear, Lordship.
Your Lordship will go by the very first order of this case. It is on 22/1/2024. In this order, Your Lordship, regarding maintainability of this petition, Your Lordship, it has been reflected as para 8, Your Lordship. Para 8 of 22/1/2024.
The maintainability of this petition is also kept open.
Kept open. It means this petition is not at all maintainable.
This is
Now herein, Your Lordship, kindly see, they have admitted that they have taken money from me.
No,
They have
no,
given,
not
they have
admitted.
given check to me.
No.
They contended that the check was given to the father of the respondent number 2.
Yeah.
But after all, money was taken, check was given. Now all other matter right now, this is the subject matter of the court below, and the court below will decide it, whether the check was given, money was taken. These are the subject matter of the court below. So I think in this case, Your Lordship, this is not a case of quashing, Your Lordship. This is not a
You
case
abuse the process of law, Lordship. You
Now,
file a
abuse will
complaint.
come when
The
abuse
check
will
was
come if there is any violation regarding filing of the complaint case. Then only the abuse will
regarding the
come.
maintenance. I
The
have
complaint petition was filed after following due procedure of the law. Now, Your Lordship, I would like to go on, sir.
So they want to go for hearing or he is
No, Lordship. Kindly call. This is kindly call for the PRC case number in this government. Already CD was called for in this. My humble prayer is kindly call. It will be clear that whether the hand note was made or not. After receipt of the case, then the
civil
case
position, Your
was
Lordship.
kindly this is that my humble already CD already called for, Lordship, and after CD after succeeded it was PRC case. Kindly call for the PRC
So
case
that
number.
case has no relevancy here.
Relevance, Lordship, because
That case has
hand
no
note
relevance.
and succeeded witness same. They are 161 statement already recorded. If you see the statement, then it will be clear that that hand note check issued to the Nebba Saleh or Imran Hussain.
No, that is the subject matter of the trial court.
No.
If you want to say that the check was not given to the respondent number 2, it was given to the father of the respondent number 2. That matter you will have to go in the court below, Your Lordship. Kindly have a look, Your Lordship, the judgment, Your Lordship.
Just see the judgment, but first of all, sir, I have noted his submission only. Now, after submitting all this, now he is submitting that case has already been there, so he wants to call for the case there.
Yes, because already PS government PS CD already or this honorable call for.
Some of the things to make the other case relevant, that's because that's why there are the hand note was whatever, rightly wrong, hand note was there. And the hand note is the case number is reflected, which was issued to you.
His father.
And issued to your father, and on the basis of when he received his notice, stating that the check was issued 10 lakh sum of paper. Then he lodged the FIR where the case is already been started. And the witnesses of the hand note are already made witnesses with the PRC. So that then should be brought something that the case may be required or not.
Each and every case is to be heard and disposed of as per one merit, Your Lordship. Now herein he is the master, I think he is school teacher. He claimed that he returned the money, thereafter the hand note was returned back, but check was not returned.
Yeah.
check was not written. What type of submission this
Yes.
is?
There is a clear evidence, Lordship, in presence
He is
of
the headmaster. Now, if there is any
Why?
evidence, I am saying, in this High Court, Your Lordship, this is not the appropriate forum. If you have any evidence, then you will have to show before the court will. That's one. Your
I
Lordship,
have a
in this
clear
judgment, Your
evidence,
Lordship, that
Lordship.
is
They
that is
cannot
there,
submit
Your Lordship.
anything that I have taken
And for that
taken
reason, Your
loan
Lordship,
of 10 lakh rupees. They are not submit anything. I have submitted a document that there is a I am not.
Submission that will come later, right? Submission will come later on.
No, I am submitted documents. You are not submitted any document that you give the 10 lakh rupees to me.
The procedure is that
In
the
his
document-
PW1, in his evidence also. Sorry.
This is a application under section 482. But 482 can be exercised in case of if Your Lordship will find that there is an misuse or abuse in the process of law, then only, otherwise not. But the claim of my friend is that they have not taken any money from the respondent number 2 or no check was given to the respondent number 2. They have shown one hand note herein that the money was taken from the father of the respondent number 2 and hand note was returned back on the day of repayment, but the check was not returned. These all are the subject matter of trial court, Your Lordship. And therefore, in the very first day, Your Lordship, on 22/1/2024, if Your Lordship will see that order, in that order, Your Lordship reflects that the case is not maintainable. So, petitioner, you will have to show that whether this case is maintainable or not. My case is that after following the due procedure of law, I have filed case, cognizance was taken, and presently I think the case is now an evidence case. So I think this case has no any, and by virtue of that judgment, Your Lordship will, if Your Lordship will go by that,
May submit.
I have marked it, Your Lordship, 4.1, Your Lordship, can be. So in the light of that, Your Lordship, this Your Lordship may dispose of this.
I have also judgment, Lordship, regarding the maintainability of this case. I want to produce, Lordship. Lordship, finally at this stage, Lordship, this is not a time, Lordship, my senior. PRC case number record, city was finally called for, Lordship. Already, why they are fair to call the CD, Lordship? There is nothing to fair, Lordship. If they are not issue any check, Lordship, I am really issue they taken loan from them.
My friend is saying that had no two person name is there as witness. My friend want to say that with the help of the statement of them, they will say something. But my case is that hand note, Your Lordship, has no any relevancy in this case. Because the signature of the respondent number 2, nor his father, is mentioned therein. It is the cellmate document. Then they can produce before the court.
Why I am Godha proceeded? You are the process of law. If I have a documents to show that convince the court, the honorable court, that this is not the case of Anaya. I am not issuing any check to you. If I have a case
on the ground of that, Your Lordship, a petition cannot be quashed. On the ground means that they are saying that the money was not given to the respondent number 2, check was not given. On that ground, is not sufficient for quashing the case. Whether the money was taken or check was given or not, it is the subject matter of the trial. The trial court will see it, and if the trial court will find that no, check was not given, money was not taken, then of course you will get.
If you just see the check also, there is only signature and writing of the amount. There is a difference, Lordship, and pay slip and writing of the amount, there is a different same person, and signature is another other. If you compare, I'll fix another date. I will satisfied there. In the meantime, case record may kindly call for in PRC case number. PRC case 686. Lordship, Goremari PS case number 89 2023. 2023. Lord.
Case number 40 of 2024 and according to those here 6 all for get record of year 6 where it is
Pending was GMFC, Lordship, Kamrup Amin Gao, Lordship.
pending for that
Lordship, scan copy of case record and case diary, Lordship. Case diary. Date me.
See, this is the case of the CPF subject. But take it with them. In NI case, most important thing is two things are there. One is positive and one is if those are with them, then the presumption will come.
Yeah.
In that case, how far NI can be called?
That I will satisfy, Lordship. There is a judgment, Lordship, in the honorable. If accused person have a documents, they can
obviously you can raise all these points done it trial could be about whether it can be some matter of washing of a bill. Okay, we are calling for it.
and a date may kindly fix.
Date cannot be fixed.
Because trial proceeding is going on, Lordship.
Huh?
Trial proceeding is going on, Lordship.
Yes, obviously trial is going on.
And the date may kindly decision. August any other any
Will be fixed on 22/8.
much of it.
Overall, four orders matters left, I think. We'll adjust and try to accommodate.
Lordship, I beg to withdraw item number 44, Lordship.
44 you want to withdraw. Why?
Lordship, with liberty to file a fresh application in the appropriate format. Lordship, this is a review petition filed against a order rejecting 311 under CRPC, Lordship. Lordship, we have to file a criminal petition, Lordship.
So you want a liberty to file a
Fresh application, Lordship.
fresh petition. Mr. M. Alam submitted that due to some technical difficulty, he wants to withdraw the same separate file where about with the liberty file. Okay.
Bless.
Lordship, item 43. On the last occasions, Dosti service was issued to the respondent number 2, Lordship, and notice was served, Lordship. Yes, Lordship. Within 7 days, I will file the affidavit, Lordship. 43.
We will then list it after 2 weeks.
Lordship.
Yes, 45. You are 45. You are in 45.
Okay.
Yes. What is it?
Service not complete.
Service not given. Right for service. Otherwise, scan copy is received that. LCF, can copy of the LCF because yes, 46, anyone is appeared. They have connected up with a long argument. In other cases, also after getting a bit long argument, there are very long. This is also time consuming. It is just if the yes, record is to be called for unnecessary time. We are running a short with the time. In fact, lots of matters are there. That apart, the lots of the ACRs are with me or from Arunachal Pradesh.
Oh.
We have to run through the judgments of the 10 numbers of judgments are connected to the that is also there.